Good morning, everyone. Nice to see you. I started the feed early this morning, as you know, to get a picture of outside the courtroom. I assume Michael Bryant has come in, right? So I've not talked to him this morning. I know you can all hear me. I think I just moved my mic a little bit closer. So I'm going to now take off my. I have you both. I have you all of your comments. I have it like in 3D. I have a computer over here. I have the computer over here. And so we'll wait to hear from Michael. We saw the line out there. Michael did tell us last night that they were going to have an overflow room today. We'll see what happens. I'm he told me that he was getting into that courthouse. So that's all I can tell you. That's all I can tell you. Anyhow, a little leftover business from last night, and also the comments. You have all been great. We're only about 600 away, a little under 600 away from getting to 40,000. Hopefully, we can get there today with all of you subscribing. But thank you to Toby Bird Dash. It is Toby Bird Dash 2322. Thank you for that major donation. Toby says, thanks you so much for bringing awareness to this devastating mental illness. And of course, all of you, Deer Beach caregiver, especially last night, were so generous. But I wanted to bring that to the attention. And then there was another donation at the end of the show. I put it actually on the show credits. So if you're worried that we didn't get to it and show it, it's on the show credits where it will be there forevermore. So we want to thank everybody for that and all. So Kevin Reddington, as you know, will go first. I do have some pictures to show of the one of our viewers sent us pictures of the playground in Duxbury that's honors the children. My understanding, by the way, that's funded by the charity that Patrick Clancy has started. That whole the child's playground that has signs celebrating the lives of Cora Dawson and Callan. So today the jury is finally going to get the case. It's obviously I see from a lot of the latecomers that have dropped in like a rock that they have an opinion but haven't watched the case. Now the law in Massachusetts, as you know, is that the defense only had to raise the issue of whether or not Lindsay Clancy had had a mental disease or defect, which apparently everyone has now agreed to, and whether she basically could tell right or wrong at the time that she committed the act and whether she had the ability to control her actions. That's kind of what the charge says in shorthand and plain English. That is the burden of proof to prove that she did is on the prosecution. It stays with the Commonwealth, the government, the prosecution, whatever you want to call them, the ADAs, throughout the trial does not shift unless and until the jury has found that the government has met its burden of proof beyond a reasonable doubt for all of the elements. The defense does not have an affirmative burden of proof like in many other states. And reading about this, apparently that really has some kind of history in the Salem witch trials, right? You want to make sure that everybody is treated fairly and not burned at the stake without the appropriate proof beyond a reasonable doubt. So that's why there's no burden apparently in Massachusetts going historically for this disease. By the way, I think that's the way it should be. Too long in this country, we downplay mental disease or defect. Everyone says, well, if you commit a crime and it's a crazy crime, of course you're sick. Yeah, okay, we agree with that. But this is a different type of situation. This whole idea of postpartum depression, which afflicts women, only women who have given birth, a very select group of women, and about 1 in 2,000 people suffer from postpartum psychosis, not just depression. And the amount of people that I can see on the internet, and if you go to social media that have talked about it, I was looking at one post last night where someone talked about that they had responded to a command hallucination that came out of the blue, all right, and could have resulted in the death of her child, right? The more the command hallucination got loud, the more confused this person was. And then it wouldn't stop there, but then she was worried whether she should call the hospital or not. And so the command hallucinations can get stronger, or they can just be strong once, and because you've had symptoms of postpartum psychosis that may have gone unnoticed or undiagnosed or properly not treated, according to Dr. Gregoire, the leading world expert in maternal, perinatal maternal health, psychiatric health, mental health. That's what happens. And you can have a voice once. And what we have objected to here in Justice Serve TV, we've tried to show in a light on this whole issue over the past year. We've done a number, we've been interested in it. We've mentioned it. We went out and found the worldwide experts, which is very easy to do. There's a doctor here right in Mount Sinai that specializes in specifically this postpartum psychosis. And of course, this trial with the prosecution and their experts got hung up on, well, initially, was it a mental disease or defect, right? They got hung up on that. And that was because of Dr. Avram Mack, remember him, who wouldn't admit that it was a disease because it wasn't in the DSM, the Diagnostic and Statistical Manual, published by the American Psychiatric Association. And then, of course, different groups have different times of onset. But in England, Australia, and Europe, who follow, and most of the world actually, indicate that postpartum psychosis can come on anytime within the first year of childbirth. And it may be that the actual psychotic break happens later. It could happen at 8 months, 9 months, 10 months, 11 months, at 12 months until the year, but that the symptoms may have been there. The psychosis may have been there and just not identified, identified instead of a psychosis, identified as depression. So if you have a chance, again, I draw everybody to our 2 interviews we did with Dr. Alain Gregoire, who, really knew his stuff and had as he said, he had no axe to grind, nothing in this race. He just explained that everything that the prosecution experts had explained was wrong in concepts, in clinical concepts. We didn't ask him specifics about this case. We just asked him, could you have postpartum depression? Could you have postpartum psychosis at this time? Can you only hear a command voice once? All that. And he was like, yes. Do you tell different stories when you've had it? Yes. Matter of fact, that was a hallmark of postpartum psychosis, that you tell different stories. You don't even know what the truth is. So you're telling different stories because you're in psychosis. And that the episode of psychosis doesn't last 1 minute, 2 minutes, 3 minutes, 4 minutes, 16 minutes. It can last for days. The psychotic break can last for days. All right. And it may have here. Remember, she dove off her second floor window head on, caused a fracture. She's quadriplegic, as is now defined, because from the sternum down, she can't move. And that is, and then she was in the hospital. And when she woke up and made her first discussion with the chaplain, she was in great grief and make sure her kids were safe. I mean, she's still in psychosis, everybody. And so this whole idea the prosecution has falsely, in my opinion, advanced that, if it's 18 minutes, that's too long for a psychotic event. Or when you're in psychosis, you make intentional decisions. You can make intentional decisions. You can make an intentional decision to put one foot in front of the other in psychosis or walking. So again, that's what I objected to. If the prosecution had tried the case with the understanding of what postpartum psychosis is, what the true facts and what it does, and the jury wants to find Lindsay Clancy guilty, then so be it. That's the way the system works. But what we have objected here at Justice Serve and tried to bring to you is the real facts dealing with postnatal maternal health, right? Perinatal, I should say, perinatal maternal health. And it's so easy. It's so easy for the prosecution to have found a real expert in this particular area. And we put one in our chat. It was right here in Mount Sinai, right behind me, just a couple of blocks down the road. And postpartum psychosis is different than bipolar. It has a lot of the same characteristics, but it's different, okay? than bipolar. And he made that very, very clear. You can have postpartum psychosis and bipolar, but when the psychotic event happens, what shows is different than the bipolar events than what shows in bipolar. But by the same time, somebody who has bipolar may be at greater risk if they're giving childbirth over and over and over to develop postpartum psychosis. It was very informative, very easy to understand. And if we can understand it and all you can understand it, the prosecution, the Commonwealth should have been able to understand it, because it is their job to do justice. It is their job to do justice. All right. And if they wanted to present it to you correctly and then argue that she knew right from wrong, fine, let them do that. But they did not do that. Okay. Instead, they got Avram Mack, and then they got Dr. Heilbrunn, and then a brilliant cross-examination by Kevin Reddington, only something that a very experienced trial attorney could do. He changed his approach to the last expert, Dr. Satoff, who, by the way, sometimes took 20 seconds to answer a question. It was painful. The first day was painful, in my opinion. The second day, he actually, I think, maybe somebody told him, just answer the question quicker, and he did. I also have a problem with how these witnesses were testifying from the prosecution, especially Satoff. The whole chair to the back of the judge and completely looking at the jury, and then let me turn up. What I do is I say, Sarah, I'm over here. I'm over here. Okay. I'm asking you the questions and I'm over here. And that usually puts them on a different road. Then they may have to turn the chair, then pivot again. And then it kind of looks like they're pandering to the jury. Yes, the jury is the ultimate decider, but come on. I mean, let's talk about it. But the brilliance of Kevin Reddington yesterday was ending with, I had initially thought it was Heilbrunn's conclusions. But he does what we all do in high-profile cases, is we order the prosecutions, if we're the defense, we order the other side's opening statement. We always do that, all right? And then we go through, usually closing, saying they said they were going to prove this, and they did. They said they were going to prove this, and they did. They said they were going to prove this, and they didn't. But what he did is take the attorney, and it was Buckingham who gave the opening statement, right? Take what she said and then read it to this witness, and he doesn't know what the opening statement was or where this was from. He just said, what Reddington said, I'm going to read you something, and I want to let, if you agree or disagree with this, all right? And again, he was asking open-ended questions, but only an experienced attorney could do, because usually in cross-examination, we never ask an open-ended question. He read the statement, and he knew, based on what the doctor had said, that he couldn't agree with it. And what it was Buckingham's delineation of how she viewed the case in one paragraph, and Satoff had to say, no, I don't agree with it. It minimizes the pain and all. And I'm not giving the exact words, but it minimizes everything that Lindsay Clancy was going through. So we end up with the prosecution starting, from a feigned suicide attempt, which make no doubt about it, that's what they were arguing, to all this other stuff that was not true. And then their own statements got skewered by their own experts. So I have never seen, I have seen, but in a high profile case, it's just so hard to do what Kevin Reddington did yesterday. You don't understand the amount of skill that went into that cross-examination. And, for the first time, you saw that he had a lot of papers on the lectern and laid out, like eight different papers laid out. But he knew exactly where he was going, but he listened to the witness. He didn't go where he was going automatically. He listened to what the witness said, and then based on what the witness said, was able to turn it into the area that he wanted to go into. So I think it was a brilliant cross-examination. I think bringing somebody in who wants to say, well, I've treated hundreds of psychotic patients, but the point is you haven't treated hundreds of perinatal maternal health psychotic patients. That's the point. And most of the times we don't hear about these cases. Why? Because in the United States, usually the women are successful in killing themselves. That's why you heard about Andrea Yates. That's why you're hearing about Lindsay Clancy. Andrea Yates didn't even try to kill herself. Lindsay Clancy did. The command voice said, this is your time to kill you and the children and you. And so we hear about it. in other countries, we're not hearing about it a lot because they identify, as Dr. Gregar said, he can identify if somebody has actually is at risk for postpartum psychosis based on the tools they have. He can even tell you the likelihood of when they would have that psychotic break, and of course, he noted that they have inpatient treatment where the mother and the child can live residentially while they get it under control. And he said, you seek help there because it is perfectly curable. Not that it couldn't come back if you have another child, but the episodes are perfectly curable. So Michael Bryant is in the courtroom. I don't know if he has suggested a tweet or not, or a post, I should say. I don't know if he's done that, but well, date night disaster. And I just see this as rolling past. Andrea Yates is following this case per her attorney. Okay, very, very interesting. Very, very interesting. Louise DB, and you're going, this is going so fast past me. I'm going to have to show some of these to stop the scroll for me. The voice literally sounds like someone is standing right next to you and can be so loud you can't understand why no one else can hear it. Yes, yeah. It's that external voice, okay? Although they have decided now it doesn't matter whether you hear it internally or externally. Before, there was the prosecution was first trying to make if you recall, thing that if it was an internal voice, it wasn't a command voice. It had to be external. But Lindsay Clancy had said she was hearing external voices. She was also hearing internal intrusive thoughts, but external voices. But then their experts said, no, it could be internal and external. So that was another thing the prosecution had misled the jury about. Okay. Now, that doesn't mean that this jury is going to find for her. You know, you could have people, as I see on the internet, who think, well, I don't really care. Yes, she is sick. Yes, she has a mental disease or defect, but I think she's got to pay, and I think she has to do some jail time. So that's that. If you have two groups, two factions in that jury room, this could be a hung jury. I don't think that anyone who thinks that she's not guilty by reason of the fact that she couldn't appreciate her conduct and conform it, I don't think those people are going to move. At least if I'm in that jury room and that's my view, I'm not moving off it. I'm just not moving off it. Yes, okay, I'll discuss. Let's discuss why you feel, but I'm not moving off it. I also think, quite frankly, that the whatever you call the Department of Corrections in Massachusetts, all right, every state has a different name, right? Whatever you call the Department of Corrections, they don't want her. She's going to cost them $1 million a year, if not more. She's going to have round-the-clock care. She's going to have somebody looking at her all the time because she is an offing herself risk. And she said she still doesn't want to be here. Not being here mean not being on this earth. So good morning, everybody. Everybody joining. Good morning, good morning, good morning. Please hit that subscribe button again. Please absolutely hit that subscribe button again. I see Cheech was in. I think Cheech was in the chat, and Jason's in the chat, and many of our regulars who have been on the air with us are in the chat. So we'll see. Michael has a tweet. There is a tweet from Michael, even though it should be a post. But, a tweet has a certain meaning as to where it comes from. So I can actually go to, I have lightning alert. I hope I don't lose my power here in New York. But let me see. Let me go to my X account, my Twitter. I still say it's Twitter. Okay. Yes, the tweet is this. Good morning from just out. Whoops, I lost it. Good morning from just outside the courtroom door. All the cops who testified in this case just went into court with the DA team. No media, no public in there yet. Shades of Kelsey Fitzsimmons. Remember when all the cops went in Kelsey Fitzsimmons, and then there was no room for other people to testify? I mean, come on. Come on. All right. You don't need to have all the cops in there, and that could also backfire here. What are they in there for? So they can hear Kevin Reddington say, and they didn't do any investigation. I'm mimicking him a little bit, right? But that really is, jurors get it. They get it. All right. Like all the cops, are they gonna have all the cops that were on the floor that the chaplain saw? Are they going to put all those cops in there, take up the whole line, take up all the seats? Now there's supposed to be an overflow room today, but I don't know how we'll have to wait for Michael to talk to us whether they were successful in getting it up, where it is, who was in it. All I know is that Michael will be in the courtroom. He said after he's been there, quite frankly, the whole time. All right. And he's with, remember initially we were supposed to go Monday, Tuesday, Wednesday, and there was supposed to be closings. And then we would pop over to the proctorology hearing, which, by the way, Grant Ellis Smith, Grant Smith Ellis, Grant, I just call him Grant. We had him on our origin interview. Very interesting character, very interesting content creator. He is the streamer for that. He is the approved court streamer for that, which means that if we want to go watch it later on, we can actually use his feed, because if you're the approved streamer, the reason why you have the feed is so other people can use the feed. All right. So anyhow, that's the tweet from Michael, just outside the courtroom door. Let's see. Let's see what else that he says. I don't see another one right now. Okay, remember, when they get into that courtroom, yes, he can have his phone because he's media. But somebody who was sketching yesterday was ejected because her phone rang. And this court does not give you a first offense, an excusable first offense. Okay, it gives you out the door offense. All right, so that's where we are with that. Let me see what you're interested in here. Yeah, we don't know who is doing the closing. I assume it's going to be Sprague. She's the head attorney. She's the lead counsel on this. And because Buckingham did the openings, I assume Sprague will do the closings. We didn't hear anything that there was going to be split closings. And, Reddington is deciding, he's tried a lot of cases. He tried the first case in Massachusetts where he had the not guilty dealing with domestic violence. And when a woman off somebody because she has been the victim of domestic violence, he has really been in the forefront of trying these cases and all. So when I talk about the male experts that the prosecution brought in, I'm not talking about them because they're of their gender, because we all know that there's a lot of staunch supporters here of Kelsey. Michael Bryant is one of them, not Kelsey, of Lindsay is one of them because of what he's seen, because of what he's heard in the courtroom. But, he understands that the jury could easily determine something else. And so we know that there's been a lot of very staunch male supporters. So Michael has a new tweet. Okay. Hold on a second. Sheila, you're going so fast past me, I can't get the tweet. There we go. We're in, but not everyone. Spillover room will carry the rest of the media and the public coming in now. Well, that's interesting. That the spillover room is going to be for both media and public. Okay. Bring your own bow. That's his next tweet. This is the best. This is Michael Bryan with the best snark. She's wearing the blend in the blend. She's wearing the blend in the black bow, kind of funereal. She's wearing the blend in black bow. I don't know what the blend is. Kind of funereal. All right. That's the tweet we need to put up, Sheila. All right. That's great. That is, yeah, there he is. He's kind of funny, kind of funereal. And by the way, everyone did go back and listen to the opening of Buckingham. And she did mention that the young little girl who was killed did like bows. Okay. So the question really is, did she do that purposely to send a message to the jury, or did she always wear bows? Okay. Here is Michael's tweet right now. Bring your own bow, BYOB. I can say pretty surely that that's what that stands for. She's wearing the blend in black bow, kind of funereal. She's wearing the blend black bow, kind of funereal. All right. So it sounds like they're moving people into the overflow room. Remember, or they're calling it the spillover room. Isn't that interesting? And all. But Michael, you can guarantee, he said he wasn't being shut out of this. Not when he's been there and all. And he's been talking to Kevin Reddington a number 2 or 3 times a week, just so you know. It's not like we haven't been doing things behind the scenes. Okay. A grown woman, she used to stop with bows. I do have to tell you all a funny story because you know how I like fashion. And I like to shop on places that are used. I make no bones about it. The Amazon, the Real, where a lot of times you can get some very nice designer clothing and accessories much cheaper than they would be because their original cost is so outrageously prohibitive. And there was this beautiful Chanel white bow, and like a barrette, a clip, a barrette, right? And I like, no way, no way. You're supposed to bring your hair back and clip it into a bow back here. I said, no way, no way, because I think I have bow PTSD. Is that possibly bow PTSD? I don't know. We'll see about that. But anyhow, yes, I am interested in how what the jury is because they have murder. We're going to hear it. We're going to hear the charges. So important. They're going to have murder too. And the reason why they're going to have manslaughter, which is going to include basically accession for both voluntary and involuntary without delineating them out because it can get confusing. Reddington wants to make sure that if there are jurors who want to convict her, that they have something and they decide to compromise, and juries do compromise, okay, that there is something lesser than murder on the table, something like manslaughter, which the judge has the discretion as to how much time to give her. And so that, and also, that has to be done with the approval of the client. It's a smart move. I know you all don't like it because it sounded yesterday initially that it was going to be all or nothing at all, murder or nothing at all. But no, it's not. And that's the reason why it's there. So that if there is a hung and they are hung like, 6-6, they could start discussing the manslaughter charge where, as I said, the judge has some discretion, a lot of discretion in how much time he can give her. I don't think, she's in her own prison to me. She's absolutely in her own prison. She has to live with what she did now that she knows what she did. She's paralyzed from the waist down. She has told everyone that she doesn't want to be on this earth. All right. She's still grieving for her kids. That was another lie the prosecution told you. They told you she didn't care for her kids. She didn't she didn't grieve for her kids. She didn't have any remorse. And then we heard from even the expert yesterday, Sadoff, the prosecution expert. We heard from him that she's still grieving from her kids. She has a lot of grief for her kids. All right. So the prosecution basically lied to the jury. Now, I would hold that against the prosecution as a juror. I'd hold it against it. You told me this, you told me this, you told me this, you told me this, you told me this. No, but that's me. I'm Italian. So I would definitely hold it against them. Because as a lawyer, if you're a defense lawyer and you lie to a jury, you can forget it. Because the only thing you have as a defense attorney is the jury believing in your integrity when you are before them. Okay? Is the jury believing in your integrity if you're before them. Okay? What I think the prosecution should be held to the state and to the same standard, if not greater, that jurors hold defense attorneys to. I think this jury probably likes Kevin Reddington, right? He has a certain charm, and he can, in the first part of the trial, he didn't really cross-examine people. Whoops, I'm seeing movement. Now, when there's movement, I will be very quiet. I don't know whether I'll keep my to be icon up or not, so it's easier for me to jump in if there is a break. But let's see, any other tweets from Michael? He's got to be careful with the phone, remember, because I don't know about you, but like my iPhone, even if I put it on silent, it beeps through some things. I have to actually turn the sound completely off. Okay, so there we go. Let's see what's happening here. Let me look. Let's go red. It's interesting how he has turned into the scrum around him getting into court today. And if you have the internet, you can go see that. The scrum around him getting into court today was pretty large. He has And I crack up because the reporters are, for the most part, so young that they call him sir, sir, sir. As a defense attorney, I don't think people have ever expressed, when you have media around you, they don't express that kind of respect as they have with him. But he does show that he commands that kind of respect and all. And he's probably finding it quite amusing. I mean, he stops to talk to some of the court reporters, some people that come to court all the time, and he's funny. He's charming and he's funny, but make no bones about it, he's tough. All right, you saw that in the courtroom. He's tough and he's prepared, and while he has his backup of his son in his office. Okay, a new tweet: Lindsay wheeled in as usual by court officer. Her 2 Tewksbury handlers right behind her. In fact, those 2 women are the only ones not sharing a pew, just them in right now. Okay, let's see, put it up on my screen here. Let's see, not a bit of cheek space, Michael Bryant says, anywhere else. So I guess people are packed in elbow to elbow, or as Michael said, cheek to cheek. All right. That's why we love our Michael Bryant, right? Because he does have this, he takes something and kind of eases the pressure that everyone is feeling. Yeah. So so far we have BYOB for Bring Your Own Bow, and we have cheek space. Okay. I wonder who he is sitting next to. This may be the only time I do want to see the gallery to see who he's sitting next to. So let's see what else is going on here. What else are you concerned about? Well, what I'm concerned about is, please all hit subscribe while you're watching us, please. We're trying to get over 40,000, and that would really be a help. Hopefully the more subscribers we get, the more we get put into that YouTube algorithm where you get pushed out. And what YouTube is now doing, if you're pushed out and people hover over you, that's considered an engagement. But if they just hit on you and let's watch the first slide, the first moment of your show, that's considered a view. Before, they had some kind of time limit that you had to watch the show before it was considered a view. So even if people were watching like 20 minutes, it may not have been a view. Calibron dogs, how is Italy coming? And how are the doggies? And are the doggies coming back is the doggie coming back to Westminster next year? Or is the doggie retired? I went to Westminster to find Calibron dogs this year, but then I missed her. Okay, I'm going to...
Court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
Well, good morning, everyone. Good morning, counsel. Good morning, Ms. Clancy. All right. The party's ready for the jury?
Yes.
All right. I'll bring them in.
Court, all rise. Jurors enter. Hear ye. All persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth within the floor of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
All right. Thank you, Madam Clerk. Well, good morning, everyone. All right. Well, you know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? Secondly, is there any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right, again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right. And that just means I'm going to give the charge as my instructions. All right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right. So they take a while. All right. And they can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right. So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, geez. I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right. Now, so my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now. So please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, To prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct, or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct, or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. It's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or two, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I previously instructed you, your decision should be based solely on the evidence and the law of this case. If the defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and/or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number 1, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and/or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation, even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and/or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of three ways. These are that the defendant A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those three ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and or Callan Clancy. 2, that the defendant A, intended to kill Cora Clancy, Dawson Clancy, and or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right. And I discussed those elements earlier when I discussed the charge or the theory of first-degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right, now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first-degree or second-degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. One, that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. Two, that the defendant intended the conduct that caused the death of Cora, Dawson, and/or Callan Clancy. And three, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates, a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right. So that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right. And I'll go over that a little bit later, but I just wanted to remind you that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right. And so, counsel?
It was about 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person be subjected to, and I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Kelly. She knows loss. And that's why we think of Cora, Dawson, Kelly. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell a jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something as I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one. A son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living her life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you, the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, the screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one hanging off of the window? Sliding down the house, and Lindsay screwed up. And she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat. Googling suicide. Googling drugs. Googling side effects. Googling ketamine treatments. Googling all of these drugs. Googling the effects of Tufts medications. Lorazepam, sertraline, hydroxyzine, lorazepam, busterone, trazodone, fluoxetine, zolpidem, myrtazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in a house with a husband and her babies, respected nurse, wife, friend, mother. Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. We'll put that over in the bad pile. Right here. We spent all that time showing through Dr. Lapasada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you have to play pool. I challenge you to tell this jury why we spent a week showing that she committed, your witnesses.
Counsel, address the jury, please.
Said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that, and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Lapasada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Lapasada and says, wrapped. They were just wrapped. They weren't knotted because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Lapasada said, yeah, I saw what you did. And she walked away like if the gloves won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children to the point where he had to struggle. And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest, he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective. And it shows the manipulation. This government This prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Laposada said, you're talking about 4 or 5 seconds, so somebody passes out. No, they gotta have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement, her throat was crushed. You heard the 911 tape. You draw the inference, whether or not there's a conversation about where the children are. Try to kill myself, the kids are in the basement, all that. You determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty, and number two, proof beyond a reasonable doubt that she was not suffering from a disease or a defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. So at the end of the day, when you're talking about, well, we've got the charges, or before the court, you can sit there in the court, you can feel proud of yourself. Do a good investigation. You even know with this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Lousy investigation of this. Well, that's okay, because she was guilty, and they put her in the hospital, and she's the evil woman who killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges, and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers? Remember Meg Collins? She came in this court, Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major surgery of her broken, crushed spine, vertebrae, rib, thyroid. Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you heard evidence, comes out of surgery, they are delusional. You've had anesthesia. You've had think about having a tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there, paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine, and then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about was they had to have this big confabulation about, we're going to take her off the, the healthcare process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that, in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You heard the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no. They were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory, not mine. One of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They got into the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolada gave it to her. So you have this evidence. You have evidence of sleep aids. You have evidence in the bag. Because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it. And we held it for 3.5 years. Anybody care about it? No. You had evidence that police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth. Second time around, hoping for a good birth. worrying about the child with the, what do you call it, the, I forget, where they rub the thing like. This woman lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking, you've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel. Told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices. Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucination. She didn't say command hallucination. I heard voices. It was a male voice. Told me. You had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2. Mac, put him aside. You've got the other doctor as well. So Mac is why he was freaked out when I asked him where he stayed. And the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective? Why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests and then go back at it again with Mack and with Halvern. And she was cooperative. She was pleasant. She was friendly. She answered the questions, and she owned what she did. Huh? She never ran from anything. She's gone through evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. You're busy. Paul Zeisel was there, literally, in Brigham and Women's, because I called him. Because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel. I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of humane feeling to try to help this young lady? And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Tewksbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. He's a good kid. He's a beautiful soul. So you have Zeisel that has been with her all that time. You've got Sheila who's been with her all that time. You've got evidence that her mom and dad who lived in Connecticut come up and they stay and they visit with her and that they sit with her, and God forbid they actually sometimes had dinner. Remember that? They get the Tewksbury records. Boy, there's a good score. Let's go through the Tewksbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly. For 3.5 years, she's acting like a human being trying to exist. But they go through the records and they want to get those dates and use them against her. Manipulation. And then you consider we're 3 weeks away from a trial. The guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet he was cooperative, she was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records, she signs the HIPAA forms, they don't know what her records are, but they know for sure what Dr. Resnick had in his report. They know for sure what Dr. Zeisel had in his report. They know for sure what Meg Spinelli had in her report, and they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her. She passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate, and more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zeisel, Dr. Condon. And they were paid for their testimony. We're all paid, like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert on malingering. You heard him testify by Zoom because he had surgery. But he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them. Everyone says they looked at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death, times 3. Has any of the government doctors rebutted that? One of them, Heilbrunn, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday who didn't even know. She didn't even know what killing during the course of the psychosis was. And when I was questioning him about it, he agreed. And I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why, the how, and the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect. As Dr. Zeisel said, that she was suffering from a disease or defect. As Dr. Condi said, she was suffering from a disease or defect, and Condi took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence, so you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied according to the guy yesterday, she lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she was, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard-charging, manipulating woman that was controlling, and everything in their life was controlled, and she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi testified when asked, did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Callan, put down for a nap. Hopefully we'll nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I don't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts. You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs. And like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote. To support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time that she killed her children. You all remember this. October. This is not an evidence, it's marker identification. It's too big. So, but basically it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? That's manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callan, because she loved her children. They were her life. Manipulation. And when you consider the journals, I don't know, you ever watched the movie The Shining with Jack Nicholson? Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice woman. She's testifying. She didn't know. I suggest to you that she didn't know having anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you got when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone. You don't measure going down the stairs. You measure stair climbing, right? That's what the testimony was. And there were 3 stairs that were climbed. Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross. What happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right? You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the baby, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You think that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live her life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was. Along with the fact it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, There's a slice of a carrot. There's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh, no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the two kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, remember, there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head, and it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
All right, Como.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue is whether, at the time she killed Cora, Dawson, and Callan, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. What's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The 2 older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callan 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, you know, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for one 25 milligram pill a day for 7 days, and then to go up to the 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan from the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you two options. Either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications. She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So you can see that in a lot of the medications she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow-through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant and she's doing what she wants to do is she has this desire to be herself again. She just wants to go back to who she was, and she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's understandable. That's relatable to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work and that it takes time for them to get into your system and it takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took weeks for the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient. She couldn't wait. She wanted faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to NGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts, you need to stick with one provider and stick with one plan to see if it works. And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over-medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication and being over-medicated, taking too much of a medication or taking too many at one time. There's a difference there. And women and infants never said she was over-medicated. What they also don't do is turn her away. It's not that she went there and they said, can't help you, go away. They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, go away, we can't help you. And her response, I'm going to talk to my provider about it for guidance. And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that women and infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she's just, no, doesn't want to do them, and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help, but she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society, and interacting with others and presenting herself as a functioning adult, a functioning mom. You know that she knew the difference between right and wrong during that time because she had those thoughts at the beginning of December of harming her kids. and she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore, didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought, that telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought, because you don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad, it's because it's wrong, it's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At MGH, she said no. So not only is she hiding it, she's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. And then we get to her being admitted to McLean. You know, up to that point, all of the drugs she's taken from September through December, they weren't given at the same time. The most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information is accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them have been out of her system for months. Zoloft, she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. The only medication she's on leaving McLean is trazodone for sleep and Valium for anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Corey's birthday party. And that's relatable, that's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. She shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. Make an appointment, pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, typical mom birthday party stuff. Everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said, seemed a little tired, but okay. The Museum of Science. You have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Codder as well. Similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen, seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report. And they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom, obviously, was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? Obviously, a very concerned, loving mom. How does Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction. And we have that text from her mom the day she leaves on the 22nd, headed back home. I'm glad to see you're doing so much better. Now her mom now wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You've got this. Take it day by day. I'm here for you. We're going to get through this. But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, I'm glad you're doing so much better, because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope, because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day. Very low dose. And then she told Dr. Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis. All the way up to January 23rd, nothing. And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication, what she took, the amounts she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness, and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. And this is on her phone. You can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Maps search to see how long it takes to get to 3V. Well, defense wants you to believe that, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the months before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have Kids Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it, and then go on to 3V, so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision-making that Dr. Satoff referenced. And then after that, she texts Patrick, you know, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialax and she knew about 3D and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialax? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And you know that's the time he leaves because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense of life experience. You're headed out the door to run an errand and someone in your home says, oh, while you're out, could you get me X, Y, and Z? And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door and she texts it to him at 5:15 p.m. And then he goes to CVS. Even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34. And then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter and it's quiet. It's quiet in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down and no answer. And he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, what did you do? And her response is, I tried to kill myself. And then it's, where are the kids? In the basement. It's not, I heard a voice. I was compelled to do this. I didn't want to do this. Go help the kids. They're hurt. They're in the basement. Go save them. No. It's, I tried to kill myself. And the kids are in the basement. And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised, her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911, he's talking to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records, you know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them, however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while, because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down and someone there for a period of time. And then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time, and then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground. And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen, in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call, that after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well. And Patrick saw Dawson eating the chicken nuggets and green beans. So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report, you can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they had, to telling him to get it, to making sure it's in stock, all of that, and he still calls her, he still interrupts her. And then she gets the knife and she goes upstairs, and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Lapisato included, it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Lapisato wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. You don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted. So I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied, but even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots, and he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson, and he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted, they weren't tied. They don't just stay there on their own. And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m., because he's making the call to her at 6:09. There's not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20 odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying, would never harm her kids this way unless she was so mentally ill that she was hearing these command voices and had no choice. But that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have, moved down to her mother's. She could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted. And when she woke in the hospital, and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children.
Counsel,
Said that was all accurate.
let's move on from that.
Lindsay Clancy hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. Leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. Somehow that works. It's a red flag that she's making up the voice. Another one is that what she said, the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance. You have to kill the kids so you can kill yourself. And then she tells the chaplain, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these 3 different versions. Another red flag, it doesn't make sense That the voice, she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice, and you have no free will whatsoever, you're just doing, your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hanged yourself. That's acting on compulsion, that's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that third prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse, those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet, she landed the wrong way and ended up paralyzed on the frozen ground. But, you know, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to, she was trying in all these different ways, but she just couldn't get over that third prong, the capability of actually killing herself. And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight, there would be no struggle, there would be no resistance to dying. But there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died. And the order also shows a rationality. The order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Kellen and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking. And we didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty, she is guilty.
All right, thank you, counsel. Now, members of the jury can sit here for a while. Does anybody need a short break? I think that would. All right. So we're going to return now to the instructions that I have. In rereading my instructions,
Jury didn't need a break.
I want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there. All right. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but specifically for the charge in murder of second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right? So I hope that cleared things up rather than confusing you any. Now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless your guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason in judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial is conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider as evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law, which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions and anything that I've said during the trial, not evidence. All right. So if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence. There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when no witness, Circumstantial evidence is when no witness can testify directly about the fact that sought to be proved, but you are presented with evidence of other facts, and then asked to draw reasonable inferences from them about the fact that sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses, all right? It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says, or only part of it, or none of it at all. If you do not believe a witness's testimony that something happened, of course, your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying, and whether the witness displays any bias in testifying, and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge. That is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field, does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias, or interest in this case. All right. Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts. All right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear. All right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard. All right? We said, so I just kind of want to make that real clear. Nobody is to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that. All right? Just kind of make that as clear as I can. Before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached your verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right? So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay? Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling this, I'm not suggesting you'll have one, but if you should do the following. All right? You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it. And then I'll either bring you back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process accounts for, may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing, send me a note, and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone. All right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks, when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. Now, while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating. All right? So no subcommittees in a sense. What you do as a group. All right? You do it all together. Now I'm going to get to a difficult part, reducing and sending out the jury. All right? When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this is a lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12. All right. And so the way it's done is the clerk will draw the alternates' names. We put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so it happens fairly regularly. They would have to substitute one of the alternate jurors into the deliberating jurors, because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. So I put in here, fate makes you an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations. It's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14.
What I kind of forgot to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. This is the verdict slip. This is what it looks like. There will be a verdict slip for each count, and it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callum Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation, or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. There's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest respectfully that each approach it with a mutual respect for the opinions of your fellow jurors. They have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do. All right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident you'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
Okay, so I'm just sitting here eating my Whoppers. Why would I be eating my Whoppers? Am I giving you a clue? I'm just kidding. This is a very serious case, obviously. And the judge is asking if they have any objection right now to the charges that were given or anything else that should be said to this jury. For the record, that's what's going on right now. It's not very secret. The question is, are they going to deliberate inside with lunch, and lunch is going to be ordered out for them, or will they go out for lunch? And it's not clear to me whether he actually mentioned that to the jury. But there you go. I mean, I think I've been posting in the comments, after you give your closing and you listen to the other side, which you don't really want to listen to, it's killing you because you want to answer everything they say. You saw Kevin Reddington, he picked up his Starbucks from under his table. I love that. And then finally drank from it and then kept it on his counsel table. But you have this heave of like, I've done everything I could. Oh my gosh, I forgot to say that. Oh my gosh, I've done everything I could. You take a deep breath. You listen to the jury charges. There's not much else that you can do at this point. And then, you have this moment of calm and peace as an attorney. And then holy terror sets in because you realize that the client has put their life in your hands, and if you have failed, it's very difficult to deal with. Right? And I'm sure Kevin Reddington, no matter how many cases he's tried, the amount of passion that he puts into it, and he said yesterday a number of times, so after the court, that he loves Lindsay, and she's sweet and she's nice. And you kind of heard that come through. I think you really heard that come through in his representation of her. So I know he's going to take this verdict, if it's anything but a not guilty by reason of insanity, personally. And of course, he has offered the option of manslaughter because you needed to give the jury that option if they want to convict her of something, because then the judge can set a sentence that doesn't have to go the full length of a manslaughter term, especially given where she is physically. So I was trying to. We don't know from Michael. I mean, we lost the last three jurors. Michael says that seat 18 is the grandmother type that he picked out, and it's interesting. In Massachusetts, as you know, so I've been telling you, the judge gets to pick the jury foreperson. And Michael Del Signore the other night mentioned, and I experienced this also when I was trying the Hernandez case, by removing that person, the judge is basically saying, hey, this is the person I think that can lead this jury fairly, honestly, et cetera, et cetera, et cetera. Some judges will pick the alternates, and then who's ever left with juror number one can be the jury foreperson. But other judges will pick the foreperson in Massachusetts now, and then pick the alternates as this judge did. We do not know, therefore, who the last three alternates were, because you're absolutely right. The clerk accidentally hit the mute button. There's no doubt about that. And so we didn't hear the last three alternates, but we don't know whether they're men or female. And remember, we started out, we had 12 women and 6 men. So we will hear from Michael Bryant. I'm looking at, he's obviously still in court, although he did say that, and we tweeted it, that there was a mass exodus from by the networks who came late. You know, they're just there to come late on a trial that's getting attention. And he said they have to go out with the superficial headline grounded in their half-day dedication to this important case. Michael's taking this very personally because he's been there, and we all know how important this case is, dealing with perinatal maternal health. All right. He also said, in case you missed it, that there was one woman who yawned, major yawn from younger woman in the middle of the front row as she follows along with court's reading of final instructions. 2 others looking at the judge but not reading along.
Do each of you solemnly swear that you will take charge of this jury and keep them in some convenient place until they have agreed, that you will not speak to them yourselves nor suffer anyone else to speak to them except by order of the court, so help you God? As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members, that you will not speak to them yourselves nor suffer anyone else to speak to them except by order of the court, so help you God?
I do.
Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jury.
Okay, so we know now they're out at 12:34. 12:34. So I put up a poll. Will the jury have a verdict today, tomorrow, Monday, or sometime thereafter? Announce a verdict or a hung. So please vote in that poll. We'll let that stay up a little, but then we'll put another one up. In terms of the poll results from that we had with regard to the attorneys, let me go to those polls. And you all know that I guess Kevin Reddington really
Jurors have exited the courtroom.
hit
All
the.
right. We could be seated.
Oops, hold on a second. Let's listen to the judge again.
I just wanted to make one comment. It really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing. It's intellectually challenging. It's physically exhausting. So I just wanted to commend all 3 counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
Okay, so he said what I've been telling you, and he's just telling everybody that you may not be aware how emotionally challenging, physically taxing it is to try a case. It's absolutely exhausting to try a case, especially day in and day out. And when you're going home, you're not going home and, oh, let me go out and go to the movies. Although I have seen some attorneys who can go to dinner late at night and come back to court. I don't know how they do it, because we and everyone I've ever worked with has never been able to do it. But now he wants to see counsel with regard to some exhibits. He said he may be with regard to some exhibits. If the jury, he may say if the jury's going to ask to hear.
When she woke in the hospital.
On call. Okay, now I don't know
She
what
knew
happened
she was
here.
alive.
Joy,
and the
why
kids
are we?
weren't.
Can we
She
take
knew
off
what she
that,
did was
Joy,
wrong.
please? Can we remove that? And I don't know why we went to there. Is that what Court TV is now, or Law and Crime is now showing, a replay of the verdicts? Because I have, let's see, when I go on here, he still should be in court. But maybe the camera's been cut. Maybe the camera's been cut. If the camera's been cut, you'll let me know. Hold on a second. Joy's about to tell me that was glitching. That was the glitching. That was the issue. So you're glitching again. All right. So that means I should go try to find this, and I'll keep talking to you all as I try to find the stream again and see where we are, because I wanted to see what was happening in that courtroom. So we're going to go to law and crime, and I'll try to bring it in. But he may be talking about some things in terms of the what's going into the jury and what happens if they want to see anything and all. So let me see. We have law and crime trials. Law and crime trials on day 22. The law and crime trials is actually replaying the closing statements here. So it's very possible that they cut the feed here. That's a possibility. Let me go to another channel. Yeah, it's very possible. Yeah, everyone's replaying things. So they may have cut the feed to the courtroom either intentionally. Let me go to Nate Eaton. He's got a verdict clock up of 2 minutes and 46 seconds. Okay. So obviously they cut the feed to the courtroom, and he's got a verdict watch clock up on East Idaho News, Courtroom Insider. Nate Eaton, we know you heard that we had Grace Wong, his producer, on the other night, who Michael Bryant worked with at Court TV, who I knew. If I recall, I believe she also did some work when Nancy Grace had her show. She's helped produce that at some point in one of the iterations of Court TV or CNN or whatever it was. All right, so that's where we are. So we're going to put up a poll. Next, we'll put up a poll with the verdict. We already put up one poll, so why don't we put up another one? But I was about to read you about Sprague. So the poll on Sprague is, how do you rate ADA Sprague's closing? 56% of you said not good, 31% said irrelevant, 9% said good, 4% said terrific. Okay. It was basically inverse. I think Kevin Reddington had as terrific. I think he had something like 63%, if I recall. Irrelevant was like 0%. Not good was 4%, and whatever the number that's left over was good. So basically, he got pretty much rave reviews, Kevin Reddington, compared to ADA Sprague. But that's also our population who's watching the show, I think. So, we may see. So I think that all of you, let's see, YouTube is censoring every streamer. Great. Okay. Well, let's try not to be censored here. Let's talk about the issues in this case. And as I'm talking to you, I will try to put up another poll here. Let me first see if Michael Bryant has tweeted anything else. Okay, so what he did say is he believes that there are 8 women and 4 men that remain on the deliberating panel. That's what he is tweeting. That's exactly what he is tweeting. Okay, there are 8 men and 4 women. He said that he said that he did some verifying as best as he could, because everyone's wiggling around and people are moving around, that the person he dubbed the grandmother is the foreperson. He said out are number 11, who he had dubbed as Tony, right? Number 12, number 14, and then the ones we missed were numbers 6, 7, and 15. 6, 7, and 15. So if we have 8 women left, that means 2 of the what did I say that we had initially? We could have had 12 women all deliberating, right? 12 and 6. Yeah. So that means that with regard to the people left, that 4 of the alternates that were pulled were women and 2 were men. So more representative panel. So the question, I assume, that you'd be asking your jury consultant right now is it better that there are 8 women who are deliberating? Will they have empathy for Lindsay Clancy, or will they say, hey, I've been through something like this. She knew what she was doing. All right. We when trying to look at social media, which is the best you could do these days with regard to, if you're not running a focus group, it doesn't matter. It doesn't seem to me it matters whether you're male or female. There are some people and men who are taking a position, and some people that are female. Although I have seen some interesting things from very right-wing conservative pundits who you would expect to be, murder is murder is murder. killing is killing is killing, have been totally against that viewpoint and said, hey, wait a second, this is a case of postpartum psychosis, and psychosis occurs quickly, and stop being a jerk about it and understand what the issues are that are going on here. So that has surprised me, and also has given me some hope that indeed maybe we can talk about these issues like we did all through our show. And again, I ask you, and once after Michael Bryant comes on, and he's probably going to take a little bit of lunch after he comes on, we'll run Dr. Gregoire's statements about postpartum psychosis, and we'll also rerun the closings as other people have done, assuming that the jury is going to have lunch, and assuming that the judge is going to dismiss them at 4 o'clock today, since they closed that courthouse at 4:30, unless they come back and say they're close to a verdict. I don't think they are. I think they're going to want to see. So the exhibits, they've been there for the whole time. So let me also keep thanking you, Dina. Dina, who's been standing in line for us. Dina, I hope that wasn't too long this morning. Donated a jewels for a flower, and of course, N Needham 8975 donated 9 jewels for a treat. Yeah, I still don't know whether these treats are for the dogs or for the us, because sometimes when we're on the air, we need a treat. But you've all been so very, very generous. So now I'm going to ask you, since you're watching this, to hit that subscribe button. I mean, I haven't checked now. Let me see where we are in the subscribers. If we picked up anyone today, I mean, you've been great. You were only, we're still about 600 away from having 40,000. So, if you can hit that subscribe button, we're trying to get to 40,000. I told Michael Bryant that you will all have us there. I said before the end of this trial. He's arguing with me. So I think you all are just incredible, and I know you want us to. Michael Bryant. Oh, by the way, okay. I missed a call, so let me take this call here, and I will say that I'm on the air. Okay. All right, and we'll see what the story is. Yes. All right. I'm actually calling Michael Bryant while I'm on the air. Of course, do I have to disclose this, because it's not really tape, but actually you can hear it, right? All right. So he is not picking up, as you can tell. Okay. He is not picking up. All right. So I will say to him, I did try to call you back. We are still on the air. We may be one of the few content creators that is still on the air, because people were being taken down. Now, I don't know why people were being taken down, why YouTube was being taken down. That's why we've asked you not to put drug names into the chat, because YouTube is dinging everybody with regard to that. And we can't mention the S word, and we can't mention the M word. And it's kind of hard to run a true crime streaming channel when you can't mention the words that the trial is about. All right. Especially when you want to bring a light and shine a light on the fact that this should not happen again. So, Michael may be interviewing. I'm sure if Kevin is outside, there's a scrum to interview him. We don't know where he's going to wait for that verdict. And that may have been also when the judge said, I want to see you about some exhibits. Usually when the judges say, where are you going to be waiting? The DAs always go back to their office. They're close by. The defense attorneys, it's hard for them to go back to our office because, to get to the courthouse and all. So the judges probably asked him where he is waiting. And so, you want to give him a little bit of peace. I mean, talk about I think a forceful closing that just shows about experience. Okay. It's forceful appearance. It said even law and crime was taken down. Wow. Okay. It's only channels with large amount of people watching. Well, that excludes us, doesn't it? We're the best kept secret in true crime. We're the best. That's what Michael Bryant said. Yeah. So you have to be careful. If you start using these words, YouTube is going to take you down, because the algorithm says you're using words of self-harm and things like that. And that's why. So I guess we're okay since the best kept secret in small crime is still here. And that's all right. I have to laugh because that's how Michael Bryant explains it. But if you get us to 40,000, maybe we won't be the best kept secret in true crime and all. I keep saying that the true crime content creators have to have a meeting, and it also has to come from like Law and Crime, who now owns Court TV, a meeting with YouTube. There has to be some kind of summit, that there has to be some kind of carve out for if you're identified as a true crime streaming channel. And that, of course, would we all know when you see it, the question is, will people take advantage of it? And that there has to be certain words that are fine. Yes, we can talk about this, right? How many times have we seen on YouTube, which is YouTube is actually the biggest search engine in the world. I don't know if you know that. The biggest search engine in the world, okay? Again, I'll repeat that. YouTube is the biggest search engine in the world. And a lot of times when we see these I can't even say the words, but these cases like the Parkland case that was in Florida, right? You see that the people that are accused had videos on YouTube of, by the way, my phone is now recording everything I am saying. So I have to now delete it. Does anyone know how you can do a whole delete of your iPhone when it's recording a message and it's before it sends? It used to be you could just shake it, right? I could just do this and shake it. All right. So I'm asking you because now I have to just put my hand on it and keep it. And I don't know what I'm going to do here with this. Let me see. I can't even. If I go here, maybe I can try to delete at least portions of it. Well, and this is going to be very horrible because I can't even delete portions of it. All right, let me just, while you all decide, you can try to help me. Okay, shut off the phone, and that will hold on the text. Let's see if it's select all. That's what I tried to do. It won't let me select all. It'll let me select part, but not all. That's exactly what I was trying to do here, so I could pick it all up and then just delete it all. And somehow it's got, wow, I didn't even say that. Wow, pretty awful. I better just delete portions of this. Not only that, but it didn't even understand my New Jersey accent. Okay, Siri, and in the middle of this, I get a lightning strike is being detected. Great. Just what I need to do is be able to go down because of a lightning storm. All right, so we'll see how that works. Let me just put this up. Thank you, Linda Michael, for all you do. A heart, thank you. We really appreciate that. Calibron Dogs, thank you for sending 500 joules. Party blowers, all right. It's me, Sharon. Thank you. I see Michael Bryant's entering the studio. I want to thank you for this. I'm going to get right to him as soon as I mags 021. 02171 member for 9 months. Thank you for all you do. I just read that. Wow. Michael Bryant.
Are we still on the air?
We are still on the air.
What the hell's going on out there?
We don't know, but apparently everybody's being taken down. But you know what? Someone said it's that it's the people with the large following. I said, well, that excludes us.
Yes, see, pays off to be the best kept secret in true crime. I'm still going through my notes to confirm the bodies that remain, but I am confident it is 8 women and 4 men. And Tony, one of the only jurors that I've identified by character and style or whatever, is the only one that got bounced as an alternate. The others are all in. Handsome Woman, Monster Garage, Dapper Dan, coming down to the front row now, Young Mother, Grandmother is the foreperson. So the others that didn't, resonate with me for whatever reason, they were just kind of in the milieu. They're mostly 30, 40-year-old men or women. And one African-American guy who was sitting next to Grandmother. Okay, so we want the whole scoop. By the way, we've had polls put up on the closings and giving everybody, rating Kevin Reddington, rating ADA Sprague. We can talk about that afterwards because now we have you here and you were in the courtroom. So we need the nitty gritty. We need the scoop. And you can give us a scoop. If people haven't noticed, Michael is in his jury watch. Yes, I know. It's kind of weird. I normally blend in a little better, but in the Justice Watch, Verdict Watch required uniform, it was probably difficult. And I know they did your favorite shot today. They did pan the gallery.
I couldn't see you though. You
oh.
know what I saw? Because the cops there at the front. Well,
Oh, right in the front, there's the wall
Well,
of
big-
blue.
right,
Yeah,
the
wall of
the
blue.
wall, the
Yeah,
wall
they,
blue.
you
And
know.
Kevin Reddington went right at them, boy. Oh,
Yes, yes, he did. Just like I think I posted, it was shades of Kelsey Fitzsimmons, where you have the support from law enforcement as they trundle in ahead of everybody else, and they take the seats, the Whoppers. You got Whoppers? You got some candy? I'd love some popcorn. You have some popcorn?
no,
They
but Whoppers was good for a closing. You have a green and check shirt. I got by Whoppers.
Okay, all right. They took all the seats that are normally empty, so it wasn't like they took anybody else's seats. Those 2 rows right behind the Commonwealth are empty, except for an occasional staff person there to sort of help out. So when the cops all poured in, yeah, they took up the spaces that were empty anyway. The Clancy family just left here and were mobbed by these morons. And they, of course, had nothing to say. This is where they've come and gone every day since I've been here, and we just exchange, hey, how you doing? Good to see you. Have a great evening. But these guys, it's an embarrassment. When the closings ended before the judge did the split instruction, which I don't mind.
I think that was that's what we wanted him to do. Remember?
Well,
excuse me, as I try. I'm sitting off my chair here.
You more often see before or after, but the split is nice. It helps the jury kind of settle into it. And then, to be honest, the bulk of the instructions he gives after are far less important.
Right.
The first ones are with the charge and burden of proof, et cetera. The others are, what's my role? What are the attorney's roles? It's fine. It's important. Has to be done. We know that. But I think to split it as he did was great. And he does a good job of trying to.
Great. It was great. I thought it was great.
Zip it up. He realizes that he's losing his audience, because they want to get out there. And I could tell they were ready to go. So
they didn't even want to break between
the
closings and they were like, whoa, no. And they're like, okay, here we go.
Yeah, they're like, let's do it. I mean, they didn't even want to know about how long it might be. Let me give you some of the mechanics before we talk about what was going on during closings and what the jury's reactions to various things or lack of reaction might have been. They will not go past 4:30 today, no matter what. Okay. And they will give us an hour will be safe. It could be even longer by the time they gather everybody, but it won't be any quicker than that. And they'll come out and make an announcement basically here in the general area. I wasn't sure if we were still on the air, I think I'm going to set up my tent and the rest of the mobile studio back where I've been at night. Just a nicer view. And this is not optimal, but it's convenient. That's why I'm here. So
well, can I tell you one thing though? We are not off the air, but our 2 polls that we had are
the polls are off.
The polls seem to be off. Isn't that
what a dumb thing that is? Why would you take the polls off?
We had 2 polls that were finished, and one that was on is about when the jury would have a verdict, and they're not here. Okay.
The bots have taken over.
Yep.
And I guess I heard that Bob was in the courtroom right in front of me, and he said, "Yeah, they took us off." I said, "Well, we're not big enough to be taken off." So, what can I tell you? And he doesn't know. He doesn't know what the deal is or how they're going to fix it. It's bizarre.
It's bizarre, and that's what I said. If I texted you that if we get taken off, just go on X and stream live. You stream live from X so that people can know what happened in the courtroom.
So, what do you want to know? What's your?
First of all, Reddington. Let's start with Reddington. Okay, let's start with Kevin Reddington.
I mean, he was as chummy as ever going in, as he tends to press the flesh. And then he brought in 3 or 4 people who were out there in the line, the 2 lines. The media is on one side. This is once you get into the building. Once you get up to the 3rd floor, then they have the lines separated, media, public. Where
were you in line?
Probably 8 or 9, something like that. But I always let people go past me because I want to be on the aisle. So I get on the aisle, and then I let people, it's like being at the movies or the sporting event. Mm-hmm. I like the aisle. Get a little better angle, and you get one because especially when you're packed in there a bit, at least you got one side that's free. But one of the things that was telling, and I know I have a continued annoyance about the Johnny Come Latelys, but there were people I could see and hear them in line saying, "Yeah, this is my first day here." What the hell? And they're the lame street media folks, and so when we're all queuing up out here, you can tell who the newbies are, and you can tell who's been here again and again and again. And so do the court officers. They know there was a spillover room. I didn't see it. I do know that there were people that were supposedly sent into it, but that's all I know. I didn't care, and I knew they were making an effort. I don't know that it would have been chock full of people. By my best guess, based on experience of how many people I knew they could cram in there might have been, a dozen or more people that didn't make it in, plus public. There were more public that didn't make it in. Anyway, so when the arguments ended, there were a number of the Johnny-come-latelys that just got up because they had to rush out. Got to rush out and be the first with their in-depth analysis on this case they spent a half a day on. I know it's the nature of the game, but it is so annoying. So. Okay, let's talk about Reddington. I don't think it was his best performance. I will say that. I don't think it was.
I loved it. I
don't think
loved it. Isn't that interesting? Okay, I
great
can't wait to hear why.
Great
Yeah, I want to hear why you think that, because I actually thought
I thought it was a little disjointed and maybe less punctuated than I would like to have seen. I think his open was much more structured, and yet still kind of freewheeling and casual, and had a lot of his personality. I think there were some great points, like when he got in trouble for pointing at the Commonwealth. He said, these people, they're trying to. Says,
but I loved it. That was right after he pointed at the cops and said,
"Yeah, he said, and that's all right. I see you guys," or whatever he said.
I don't care how many I don't care how many of you are here, and he pointed to them, right?
And there's there goes some more. I can hear the cuffs jingling. Anyway, well, let me show you this guy over here. Let me see if I can show you this guy. See this guy right there? Oh, he's just walking by the building. Yeah. Older gentleman. See him? He's just like right. That's good friend of Kevin Reddington's. I saw him the other day. Kevin went up to him and said, "Hey, thanks for coming. Appreciate it." So I was asking him, what's the connection? What's the deal? He said, "Well, I used to do cases." And I thought, oh, he's an attorney. He's a cop. He's just a cop who now lives in the area, but they both came from what part of Mass? He's mentioned it before. Anyway, I can't think of it offhand, but they're buddies from back in the day. And I said, so you used to, if he was a defense attorney and you're a cop, I'm pretty sure you were, maybe on opposite ends of some of these cases. I said, it was nice that you came to say hi. And I said, he's a dynamo, that guy. And his friend said, yeah, but I beat him. So
that's funny. That's funny.
So,
yeah, they're going back on.
So anyway, I just think it was just a little less structured in a way that, and he obviously went much longer than he had thought he would. He went 53 minutes.
That's right.
And I don't know how he could have gone shorter. Really, I do think he hit all the high points. I do think he pounded away on the people that were the worst. The Commonwealth experts, which were a joke.
And the Commonwealth themselves, in terms of putting her on trial, saying this was a feigned suicide event, right?
Yep. Yeah. And he had plenty to work with, and I get that. And certainly I'm not comparing him with the Commonwealth. I'm comparing him opening, him closing. I just think if the opening was a 9, this was a 8. I think he just could have been a little more structured. You liked it though. You thought it was great.
Yeah, I thought it was great because of his emotional impact.
Sure.
I think one of the things that he had to get across the jury is how much he really cares about the client. And I thought that by losing some of the structure, he was able to get the emotion back in. And that was my feeling about it. That I thought that was what was great about it.
Well, I'll tell you about his, he is the king of vocal variety, which for any performer knows that's very important. When you talk more forcefully, when you bring it down, he starts so quietly. I'm only, maybe 15 feet from the guy. I could hardly hear him. So
At some point,
at the very beginning, when he's, he has his relatively routine spiel, you can tell about, thank you for your service, et cetera. It's, this was difficult and all of that very, kind of setup stuff. And, but I'm thinking, well, the jury's right there in front of him. Obviously they can hear better than I, but man, he was quiet when he first started. And then he built to a couple of crescendos in the middle of the process, both pointing at the Commonwealth, talking about the cops, talking about the doctors. There was plenty to work with. And then he had, when he was focusing on his chalks, I would love to have. I know the camera had a probably better shot than I did because it was a little more over to the side. I thought that was effective, and he was sort of kind of sorting through the evidence in a way, stacking it for his case. I thought that was effective from my perspective. Did you?
It's
Did you
hard. It was
agree?
hard for us to see. He had the one chalk dealing with the message from her to the mom,
Right.
but what we were hearing on the television, I had to use that word, was
He made
like a
fun
lot
of
of
himself about that too.
a banging. Like every time he put it down, it was hitting the sound, the mic, and
Yeah.
that took away from the effectiveness of listening.
Oh,
to
interesting. Because I could see that, and that was what I was trying to see was he wouldn't be doing that right on their table, but it was right adjacent to their table, almost to the point that it was like he's slamming it down on their table. That's how close it was. But yeah, I like that kind of stuff. I think that's
Yeah, me
effective,
too.
and when he is able to punctuate a point with that, we always kid if the law's on your side, pound on the law. If the facts are on your side, pound on the facts, and if the neither's on your side, pound on the table. But he's pounding on the table with some of his better facts.
Mm-hmm. Yeah, and that's why I threw this up, because he walked backwards to these exhibits back here, and at one point he stood. I was trying to grab a screenshot. He just stood there. I mean, it was like it was like God was on the cross. Okay, he was in the black suit, just standing there, and it was such an imposing figure, such an imposing look. And this is just as he took the first step away from that stance. And I thought that was very imposing, that you really had to pay attention to him. And I thought his snark about the chicken McNuggets,
Yes, which was actually a conflict in terms of the evidence that didn't really resonate with me the first time as it was unfolding. But he did a good job of kind of bringing that back together: the green beans and the chicken nuggets. Who's going to know what's in that food? Who's going to know what Dawson's eating? Probably not Dad. Probably Mom.
Yeah, and then as you said, when he called it the prosecutor, I challenge you, and the judge said, "Whoa,
Talk
whoa."
to the jury.
But he got the point across.
Look,
he knows what he's doing, right? I mean, he knows what he's doing.
And there were times when that picture you showed was similar. He would back up so that it was impossible for the jury not to be looking at both he and Lindsay at the same time, right? If he stays closer to them, they could focus on him, and she's kind of off in the background. But when he takes a few steps back, not only does the camera take in both, and they're very glad to do that, but the jury, more importantly, sees his connection to her. And there were times where she was very emotional again. I don't know how much of that was shown because the camera's on him performing most of the time, but I'm sure you must have seen some of her emoting.
Oh yeah. Yeah. We saw some of it. The camera moved at some points when she was emoting, the camera then moved, and I don't know why. I guess, because he was there. This is my exception to there always has to be somebody seated next to the client. The
Yes,
jury has to see her. The jury has to see her. So we have a question from one of our members. What did you think about the quarters and what Attorney Sprague did in response?
It wasn't clear to me. I know she picked one up off her desk. I wasn't following. Maybe I missed it. I wasn't following. So
yeah.
Tell me, was there a message in there?
Yeah, I didn't think anything of it because I think I missed it. So there you go, right?
Yeah, and she was very flatline she was 54 minutes and probably 50 minutes was flatline, and then she decided to amp it up for the big finish, right? It's just not an effective way to talk to the jury. It's great if you're talking to your friends. Just that matter of fact, have a conversation, but with zero emotion in anything she's saying. And she's talking about some pretty emotional stuff.
Well, I mean, I guess she didn't want to be accused of doing what she did during the trial. So let me ask you this. What was Kevin Reddington's high point and his low point and then what was, Attorney Jen Sprague's high point and low point?
Easy with Kevin, because I think because I wasn't in the jury, I wasn't the target audience. It was just too low. It was so low that I guess it made his higher volume points more punctuated because it was so different from what he was doing. But I think it just seemed almost thrown away. So that was for me a low point, but I wasn't in the jury. I wasn't able to actually, take it in as well as they must have. And then I think the high point is when he had those pictures and he said, what takes us from this to this, right?
That's right.
You know,
Right,
and
right.
talking, there's a picture of the
right.
happy family, and then this. I think that was because from the very beginning, you know, I say this, I repeat myself all the time. You've got to find something that drove this mom to do this, something, and that's what takes you from this to this.
Yeah.
Something. And if it's not the drugs or the disease, what is it?
Yeah, and he answered that. He said it was the drugs and the bad medical care, right?
Yeah.
That he used the word government a lot, which I love. And that's, you know, that's for those of us who try federal cases. We say government because the government is
It
like,
is
whatever
right.
reason, the
It's
state,
the
the
U.S.
Commonwealth,
government.
yeah, the state, the Commonwealth, and all. But you can tell because he uses the word government, and I counted he uses the word government at least 5 times in that 53 minutes, maybe
okay.
more. But did he ever use the word, postpartum psychosis?
As opposed to just illness and
Right.
trying to get help. And that's a good question. If he did, it didn't resonate with me, or he didn't say it enough to resonate. We know that
Yeah.
the Commonwealth basically said that there was never really any, evidence of that psychosis.
Yeah, he bragged on the experts though. So before we
Oh,
get
yeah.
to Attorney Sprague, we're talking about Attorney Reddington. I guess I have to formally say Attorney Kevin Reddington
Yes, please.
because
Don't say Kev.
Don't say Kevin. Attorney, he really ragged on the experts. What was his best argument on the experts against
Well,
the Commonwealth?
I think it was so easy because they were all ill-suited. So they didn't know enough about the subject upon which they're supposedly experts. How are you an expert? And he basically just pointed out what everybody, I think, watching them saw, which was him saying, well, how many times have you seen a woman with psychosis or postpartum? And you're hearing 0 and 1 and 2. So I think all he did was point out the same stuff that he pointed out during the cross-examination of each of these witnesses. You're not qualified. So jury, I wouldn't give him, when it came to Mac, as he started calling Mac, I don't know why you would think of, what did he say? If you even consider his testimony, and I don't know why you would, something like that.
Right.
Totally dismissive of the guy. And I think that was justified. Sorry,
Yeah.
Commonwealth, do better.
Okay, so the next word he used the most, and this to me was the theme of his closing, was manipulation. Talk to us about that.
Well, let me see. I'm trying to think how that.
So I have it counted at least 10 times.
Well, I mean, we know what we're talking about because his theme at the opening and at the beginning of the closing was these coppers here. They did no investigation of any kind, and the only way they could get his client was by effectively manipulating what they did have and turning it into a case. He goes into how she's been, thoroughly destroyed. And I get it when people say, well, yes, she killed 3 young kids. So, you can't, nobody's putting a halo over her head.
Right.
But to me, that was his reference to manipulation. I'm not sure. What did you get out of it? And at what point?
I thought it was just, it was thematic. I thought the closing was thematic, that they lied to you, they're manipulating to you. The experts lied to you, they're manipulating to you. The cops didn't do anything, they're manipulating. So they're taking everything that's factual and manipulating. And then I thought he punctuated that. I thought the best punctuation of that, quite frankly, and something I had not heard before, and I don't know because we don't get to see the exhibits. He talked about her diary where she wrote everything down,
right.
And it was just so detailed and this and that. And then she says, and you get to January, and what do you see? Nothing but chicken scratch. I was like,
yeah, and he used The Shining. Interesting reference to The Shining, right?
Yeah, right.
When he first said that, I'm sure people have seen. There are some memes and things out there of the Commonwealth twins. And for those who remember The Shining, there were those girls, the twin girls in The Shining, and they have been morphed into these girls. So if you haven't seen it, it's pretty clever. But when he mentioned that, the first thing that popped into my head was, wait a minute, where's he going with that? Because my most recent reference to Shining is what these people did with the twins from the movie. But no, he's talking about how when the character played by
Jack Nicholson.
Jack Nicholson is writing. He's an author, right? So that's the deal. He's going to be squirreled away in this remote house. And so he's, you see him frantically writing or typing. I can't remember, but whatever he's doing, when you finally see the page, it just says, all work and no play makes Jack a dull boy. And it goes just again and again and again, just repeated in a manic kind of psychosis. And so he drew that parallel with her journal. That journal,
Yeah.
if I were in the jury, I'd be pouring through that journal.
Oh, right now, I'd be going to right now, because if you're telling me that she's like writing everything down, if she starts her medications and then it goes to illegible chicken scratch
Gibberish, yeah.
for the gibberish to the month of January, I'd say to me that became one of the most important pieces of evidence I think I've heard on this trial.
Yeah, because we only heard bits and pieces of it, from different witnesses, especially from Patrick. But the fact that the whole thing is in, man, that's got to be some interesting reading.
Yeah, yeah. So how about with the jurors? Do you think that The Shining was lost on the? I guess I should ask this.
On
You
the
have a
younger
younger,
ones?
yeah.
On the
You
younger
have
ones?
an older jury who would know Jack Nicholson and know The Shining, and then you have a younger jury. I don't know who obviously is on the jury in terms of age. You haven't gone through that, even if it's eight.
Yeah, and I've got to get my other notepad just so I can confirm what I've got. I knew the folks that I had identified more specifically are all in, and if we look at those, just going across the top, a female, 40-ish. She's the one that's been known to look like she's dozing off a little bit, just a little bit. And then next to her is the handsome woman. And then it is one more person who's a little more nondescript. I can't remember, but they're in. That would be number 3. Number 4 is Monster Garage, and he's in. That's the guy who's 50-ish, got the goatee and everything. Then number 6 is, again, I check my notes. It's a woman. I can't remember more detail than that. And then we have Dapper Dan, who is in. It wouldn't be interesting if when they have a verdict, he comes out in sweats and a T-shirt, after he's worn a tie and a vest pretty much every other time. It's the inverse. Get it, Linda? It's the inverse of what we see if they come dressed up.
By the way, someone says Court TV says it's 9 women and 3 men. We had it as
I
8.
have it as 8 and 4, and I'll
We'll
see
go back and
where
check.
that number's messed up, unless I misgendered somebody. And if that's possible, it's from the far end of one of the rows. But yeah, we'll definitely have a chance to go back through that. I want to see the selection process. I know I got down solid. We didn't know at first.
We were glitched, and not everybody was glitched. Apparently, the court clerk, when she's shaking that box around, like
Right.
if I shake my
She
rockers
hit the
around,
microphone.
She hit the microphone, and so we didn't hear the last after 385 during the 14. We didn't hear the last 3 until the judge then came back and started talking to them.
Okay. And I checked with 2 other people in terms of men and women. So I'd love to know where the 9 and 3 came from, if it was some source or just somebody else's guess.
Right.
Anyway, so then across
that'd
the front, we have Tony got struck. That's the only only juror that I had sort of created a persona around. He got struck. But grandmother is the foreperson. Young mother is also in as well, which I think is very interesting. She, during closings for the Commonwealth, I don't think she ever looked.
Yeah, we haven't talked about
Miss
the Commonwealth.
Craig.
We haven't gone to the Commonwealth yet. Should we
Okay,
take a intermezzo and just go do some of these for our members?
Yes.
Ruby 3595. Thank you, Ruby, for that donation. Commonwealth is manipulating. Commonwealth are the ones manipulating. Use their theme. Kevin Reddington used the theme against them, and then and Needham 8975. These are repeat offenders. Quarter on the pool table. I got the next game. Thank you for that donation, and of course, Undercover Angel again, gold coin. Undercover Angel 11, and Michelle MDT. Hiding 10 jewels. Okay. And then of course, Date Night Disaster. Thank you, Date Night Disaster. You are, you're a great friend to this channel.
Yes.
Gifted 5 Justice Serve TV memberships. They've already been given out. If you feel in your heart, pay it forward. If you get one of those free memberships, pay it forward if you can afford it, because it's a lot of money for a lot of people. Hiding again, Louise, D8P2B, Hiding, I love the fact it's 2B. Yucca Valley and 2074, 1000 Jewels, gold trophy. And Needham 8975. Again, repeat offenders, 10 Jewels, thumbs up. And this is Lulubell, 1. Gift of another
yeah.
5 months to serve TV
Lulubell was very
membership.
active yesterday, as I recall.
Yeah, Lulubell, thank you very much. Julie Nelson, 194, wants to know, do we know how late they could deliberate? I think Michael said till 4:30 they're closing it down.
Yeah, they close up shop at 4:30. It's a
Yeah.
manpower thing. And as I was told, especially this early in the process.
Yeah.
Tomorrow,
Melissa Boyles,
if they told if the jury made it clear at some point tomorrow that we're getting close, I think they will extend the end of day.
Melissa Boyles, again, in 100 Jewels, high five. And MI Mastiff Mama, 10 Jewels, floating heart. So thank you for all of these donations. Now,
I got a couple before we go into it.
Yeah.
Melinda, thank you so much. Thanks for your coverage, she says. And Kathleen, repeat offender, thanks for your commentary. And she calls herself a repeat offender. So
yeah, and Sun Moon M5Y 100 Jewels, high five. Okay, so took that little intermezzo. Anything else you want to tell us about Reddington and how the jury was reacting to him? I guess.
Yeah. By contrast, and we can use this to dovetail into the Commonwealth. He gets their attention, and first of all, the beauty of being first, even though there's been some instruction by the court, you're the first, so you could be horrible and still get a certain level of attention. But they watched every move he made. There was no drifting eyes. There was no fidgeting. No notes. Not that they aren't allowed to, but nobody was taking any notes. And he held the audience as you would expect that he would. It was, to that degree, it was not any different than anything I've seen him do in this courtroom. He gets their attention. He holds their attention. I think sometimes they wonder just what he's going to do, because he does throw some oddballs out there occasionally, and so now contrast that with the Commonwealth, where young mother, I swear she was just, I kept looking, because my angle is, I'm looking sort of down the 2 rows of the jurors. I'm not looking head on. I'm not looking. So I said, maybe I'm missing something, but I could tell by looking at the people on each side of her, who were looking at Miss Jen. They were looking at Jenny, and
that's
young
Attorney
mother,
Sprague to you.
Yeah, that's what I meant. And young mother was looking like between them, as if directly across the room. I just thought that was very odd. Totally checked out from what I could tell from that vantage point. I could see very clearly everybody else watching her and listening to her, and I think they were cordial. And toward the end, I did see a little, maybe less attention given to her directly. There wasn't anybody, nodding off, nobody chatting, nobody taking notes with her either. But I think they were just getting, tired. That was 2 hours plus the instructions, right? So now they're sitting there almost 3, and they know they got some instructions still to go. I just think fatigue was setting in, and they weren't learning. If you don't have a speaker that's dynamic, then it just gets boring, and you're hearing stuff that you've heard 100 times. And in this case, we were wondering what we were going to hear about the change in theory from it was a fake suicide to it was just a bad suicide to whatever else they were going to argue. Right. That here's the one thing she talked about, and you talked about highs and lows. There were a lot of just flat spots. I don't even know if she made it past low, but the interesting and the high point I thought of their argument was where she talked about having knowledge of the order in which the children were killed, because other than statements allegedly made by Lindsay Clancy to different healthcare providers or to the chaplain, it's far from clear how that all happened. But she used this plan. That was her argument was there's no way this was psychosis. Look at the plan. This voice thing, first of all, don't even believe that. It never happened before. It only happened on this day, way too convenient. And besides, if she's in this psychotic state, does she know what she's going to do, where she's going to do it, what she's going to use to do it? So she's ticking off all of those boxes. But in the midst of that, she's saying that Dawson was selected, effectively selected to go first, and used Dad's office as a way to sort of separate that action from whatever else was going on in the house with the two kids, the other two kids, including the baby. So I think she went. She definitely inferred a lot that I don't think there was direct evidence of, and that's okay. You can do that. I just don't know.
What about
effective.
this? What about the fact that when she was doing that, and she said the reason why we know that she wasn't in psychosis is if she's in psychosis is that she would have used the same
band
method, the same
Oh,
method to
the
kill
same method.
herself as she did on the kids.
So
Where
I mean,
did
where do you
that
get
come
that?
from?
Where do you get that?
Where did that come from? Right.
I'm sorry. I'm gonna have to look for her medical degree and focus on psychiatric medicine. Yeah, I don't get that. But she did try to talk about going down with the ship on the whole loose band thing, right? And Reddington mentioned it basically to say, well, what the hell was that? We already heard from compare that, jury, with what Patrick Clancy told you. He said he put a half knot in there that he had to undo that half knot that was in place that Lindsay Clancy put there. He didn't just unwind it from each of these children's throats. So contrast that, ladies and gentlemen of the jury, with what you're being told and the demonstration, which he really mocked. He mocked her little loose wrap the cord around the neck demo
Falling
with
down on the
Dr.
falling down on
LaPosada.
falling down on the desk. Yeah.
And she tried to double down on that, saying that there's no way those bands stay in place without somebody constantly pulling on them. Now, if I were better at my job, I would have one of those, and I would try to just. I believe there is natural friction because they're rubber, right?
Right.
I think there's natural friction that when you pull them together, and we'll have to get one, and just as we're decompressing over this case over the time that we both deliberate and talk about the verdict, whatever it may be, I think you can show that you stretch those things tight, and the friction and the material will maintain a constricture, in this case, as a ligature on each of the children's necks.
Yeah.
I wish there had been more about the timing. I know that it was more talked about by the Commonwealth than by Reddington, and she did it in the context of poo-pooing what LaPosada said.
Yeah.
Yeah. And so that whole, 18, 20 minutes is kind of the prevailing thought that the jury might still have stuck in their heads. And I think that's an issue for the defense.
And what was the low point of her closing?
Oh, gosh. Let's see.
I know it may be hard to choose.
And there are quite a few. And if I'm, without even looking at my notes, if I think about it, then it must be a low point. And I really keep circling back to her basically trying to dig out from the hole created during the course of the trial, among other things. How many times did she say she was trying to get help? She was trying to get help. Remember that? I mean, that was a theme. To me, that was giving in, because that was never their position when they started this case, that she was ever trying to help. If she was trying to do anything, it was drug seeking, right?
Right.
So I thought, to me, that to make that kind of obvious shift to look at us, we care. She was looking for help. It was just, in all the wrong places, as somebody once said. So that to me was just very difficult, I think, to sell the jury at this point.
Yeah. So very, very, very interesting. How about your overall feel of the vibe in the courtroom? What was your overall feel?
There's always such anticipation, for especially those that have been there and seen it all unfold. You get invested in what's going on in the players, in the law, in the facts, and you feel like this is kind of the calm now before the storm, which will be the verdict. So I think those who have followed along hope that both sides do a decent job wrapping up the case, because the jury is the most important audience in there. That's not me. It's not you. It's not anybody else watching this. It's the jury. And so I don't think anybody's wishing anybody ill will. Like, I hope they tank this. No, I don't think that's true. I think everybody trusts in the process and feels good about the process, no matter how much we might, criticize certain players. So I felt that with those, because there's a ton of us that have just been there, if not from day one, certainly weeks rather than hours.
Right. You've been there. You've definitely been there all this week. And so M. Brass 6073 37 has a comment. Thank you for the donation. I vote the whole Lindsay had good insurance low. I guess I must have missed that line. Must have been so out of league. I missed it.
What was that? She had good insurance. That was the Commonwealth said that?
Yeah.
Yeah, I must have missed it.
I must have missed it too. And we have another important question. Was the dog back in court? Thank you for that donation.
No.
And Needham 8975.
No. Homer Achilles, the pug Frenchie was not back in
He's
court.
not back
today.
in court. Okay.
And neither was the flower person.
No, and Needham 8975 gold coin. Thank you again. And before we go on, Angela and
Angela. Oh, okay.
Angelo L and Grieve 693030 joules. I'm sorry if I mispronounced your name. Part of it is that I can't see when my computer is this far back, and we're trying to get a whole picture here. 750 joules, Michelle MDT, 750 joules. Let them cook. Let them cook. Okay. Thank you very much for these. Okay. I'm just trying not to get, behind on it, because you all have been so very generous supporting Michael in his trip up to, up there. And you were going to actually today, you thought this would be over and you were going to go over to see the proctorology hearing, which Grant, by the way, got the approval to be the streaming network for.
Good.
And
Good.
so, and he's already said that anyone can reuse, obviously, as a streaming.
Is that at
network.
2:00 or is that?
I think it's this afternoon. Yeah, I thought,
afternoon,
I could be wrong. I mean, it's been a little busy here with our polls. So we do have a poll up right now as to when you think the jury is going to have a verdict. If it wasn't taken down, okay, if it wasn't taken down, let me see. Before, when I looked, I couldn't find our polls. And I was like, really? What happened to our polls? Where did they go? Yeah, I mean, on mine, do you guys see a poll? Because on mine, the two polls we put up this morning,
they're gone now too.
They're gone, and the one that we put up about the time of the jury verdict is gone. So if you see them, let me know. I don't have them here. Very interesting. Very interesting. Mine, they're gone. Mine, they have disappeared. Okay, they have disappeared. See, it looks like Melanie has her stream back up, and it looks like Defense Diaries is back up. So whatever happened has been
fixed
resolved,
somehow.
has been fixed
good.
for the moment. Okay, that's the good news. That is the good news.
Here's another.
What else haven't I asked you, Michael, that you want to
I
tell
was
us?
just looking at my notes here about some of the things Commonwealth said that I thought were, those 180 turns. One was that, hey, she was trying to help herself. She's looking for help. The other was that there's no dispute that she had a mental illness.
Mhm.
There's no dispute over that. I mean,
Well, there was when we started.
well,
they
yes.
disputed.
Yes,
Yeah.
that's what I'm saying. It's a 180 that they've taken from the very beginning. The very beginning, it was all, she's cunning and she's got this master plan and she carried it out.
Yeah.
Well, that didn't work. And so they changed that in the closing to be nobody's disputing that she has mental illness or that she tried to kill herself. That was the phrase. Really?
Well, that's because they're
somebody
experts.
was.
Somebody you were, and you were
Yeah.
knowing what your experts had felt. All right, everyone else seems to have a poll but me, but that's good as long as you have the poll. That's great. Are they?
Yeah, let's
working
have a
through
poll
lunch?
about whether or not Linda has the poll. How about that?
Okay. Are they working through lunch, by the way? Are
They have that option, and they were just getting down to the first lunch. So again, they don't micromanage them to that degree. If they want to, they can. If they don't want to, they could take a little breather. What he did say, which I thought was funny, he says, but if some people do want to talk a little bit and others don't, you can't have subcommittees. You can't have subcommittees, breaking out during the lunch. You gotta do it all together at the same time. So
That's kind of cute.
Yeah.
Where are the alternates being kept?
It's just somewhere in another, in some soundproof booth, like the dating game. I don't know. They're somewhere in another room, wondering how to pass the time. That is the worst part. I mean, not just that you've been selected, because now, but you can't even go home. You got to stay here. And by the way, don't talk about the case.
Except that we didn't see what was the case. What was the case? Was it Karen Reed? It may have been Karen Reed that she sent them home.
I can't remember. I think I remember from another state. It definitely happened more than once. Can't read it, to be honest. I can't remember.
Yeah. Oh wow. And I assume Lindsay Clancy stays in the courthouse and not transferring her back.
Yeah, she's got basically it's a holding cell. I don't know, if it looks like a cell or it's just a room, but they call it the holding cell.
Yeah.
Dr. Z is here today. So she's got as big a support system as she's had as this thing's gone on, except the father's not here. The priest is not here.
Okay.
So.
Wow. All right. So far the poll people voting, most people think 41% think it's tomorrow that we're going to have a verdict. But juries, you never know. It depends on what they're going to do, right? It depends on what the foreperson decides to do. Do they go and say, do we take a straw poll, see where everyone's at? There was one case, and I think it may have been Karen Reed, where the judge said, advised not to do that. Remember?
Yeah, it was almost like it was a standard instruction that she was reading, but
Right.
I've never heard that one before.
No, neither have I. Normally they leave it up to the foreperson to decide how to proceed, and it was the Corey Richards case. Was it the Corey Richards case
In Utah?
Yeah, maybe.
No, I don't think so. I think I remember being
Yeah.
in the room or outside. I remember that, and we talked about that at the time. Like, really? Because that's human nature. First thing,
Okay.
one of the first things you want to do.
So Joy, are you back from walking the puppies?
Yeah.
I see Joy was walking, and she had to go walk her dogs about 7 minutes ago, so she may not be back because
Okay.
when she comes back, what I would suggest we do.
Okay, well, maybe suggesting something would be to take herself off. Anyway, I was going to mention something about grandmother that you may not remember why she caught my attention when she did. Do I have to? Are you bringing yourself back on? Do I have to bring you on?
No,
Did I have to bring
glitched.
you on?
No,
I don't know.
I glitched.
That's weird.
I don't know. That was weird. I mean, I just saw it happen. I was like, whoa! I could see the whole thing going on. I'm like, please don't let me have taken down the stream in some way, because
Only half the stream.
We have this
Just
huge lightning storm that's going to happen here, and I'm thinking,
Oh,
no,
is
that's
there?
all I need.
I didn't know
That's
that,
all I
really?
need. Yeah.
That's what my my softball team. I obviously wasn't going to be available for tonight's game, but a lot of people were saying it's supposed to be raining down there.
Yeah,
So
supposed to be
we're
terrible.
far enough north.
Right.
It is very windy up here, even windier than yesterday. It blew our tent over, but
But as soon as Joy gets back, what I'd like to do is bring in the and she may have it, but right now it's if I add this to the stage, can we see whether this is I have to remove the stage because I don't know if that is Joy's back. Okay, let's see what she's saying to me. She's back. Joy, can you play the closings starting with Kevin Reddington?
we
will be around if the jury, if they come back, and we'll bring the feedback in.
Yeah, we'll get plenty of notice, and then what I think we'll do is once there's notice that they have not reached a verdict and they're being dismissed, we'll pop on and kind of sum that up, or at least I will. I don't want to commit you for that little blip, and then we'll circle back to our 6 o'clock.
6 o'clock show.
Before I was going on a little comment here about grandmother and what got my attention about her, because I didn't identify her right off as somebody of interest, but she was a major note taker with the medical experts. Major note taker. Like, I don't know, I saw her whole face because her head was down most of the time, and she had a ton of tablets. Okay,
and that's maybe why the judge picked her as to be a foreperson.
That could be, but it also could be that, hey, he always picks number 18, or whoever's on the end of that row. If you've got 14 jurors, maybe he always picks number 14. But
did we decide where now you know where 18 is? Where's one?
One would be sitting next to Handsome Woman,
which is where to the judge towards the
Oh, okay. So if he's looking at the box, top row left is the woman with dark hair, glasses, who tended to fade off, it seemed to me. Right next to her is Handsome Woman. Okay, so that's, if you're looking at the wall, 9, you got 9 and 9. Okay, Handsome Woman second from the left on the top row. On the bottom, now gone, 10 and 11 and 12. They got hit bad on the bottom row, but Tony was 11. So he would be.
I was thinking, wow, 11, 12, and 14, and then 15. So 11, 12, 14, and then 15.
The bottom row got decimated. Yeah. Interestingly, though, none of the, other than Tony, none of those that I had kind of keyed in on for various reasons. So I still got to check. If somebody thinks it's 9 and 3, I will triple check. But I've done some checking, but I want to make sure we're reporting the exact numbers.
Joy's just having a problem now, having a court channel up and getting to the closings. To change.
Are you reading some?
I'm reading from Joy. She says that she had a court channel up to do the closings, and it changed her feed. And now when I'm looking at our green room below, There is no court channel up now. So we're going to wait for the court
There's
channel.
another one.
I
There's a
think
feed of some sort.
there's some feed stuff coming in. And as soon as we can get that up and start running, you're going to go take a rest.
Yeah, I'm going to go kind of suss things out and see if it's worth setting up the tent out there and the Starlink. I don't know if I have enough weights to keep things from blowing all over the place.
Yeah. Yeah.
But then, obviously we'll just pop back on when there is news of anything.
Yep.
And
so
we
just-
know it's already 1:30, which means it's 3 hours
Right.
at most
Nothing.
today,
Right.
at most.
And they may be tired. They may be getting organized, getting
Yeah,
tired.
I think this is the
Yeah.
perfect amount of time to kind of have that conversation, that when you've been withholding for 5 weeks, just blah, 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 just whatever thoughts have been sitting there on the front of your head and you just got to blurt out. I think there's a lot of that going on. And
Yeah.
then,
Joy, can you put it up with Michael still on the screen? Can you put it up? We'll go to the double side, and then when
then you
it's all
start
the way
to
up.
settle down a little bit.
Okay,
and I
so
think
there-
that's tomorrow.
Yeah, and there you have it. So we're going to start. Michael and I are going to pop off, but we'll be monitoring, and we will pop on as soon as it looks like there's some movement in the court, and we will take the stream off and put the actual court stream on. So thank
All
you
right,
for
guys.
joining us. Please stay with us. Please vote in the poll, and please get us to 40,000. We need 600 more people to hit that subscribe button. We have over 3,000 watching. Can we have 600 of you hit that subscribe button, please? Please, pretty please.
Yeah, we're trying to get large enough that they take us off. Is that our
Right.
goal? That's
Right, that's our goal. That's our goal.
That's weird. Okay, see y'all later.
See you later. Bye.
From a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right. So that's my instruction.
Has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Jurors. About 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I think I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Correct. Dawson. Callan. She knows loss. And that's why we think Cora, Dawson, Callan. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell the jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something. As I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will than likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living real life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one hanging off of the window, sliding down the house, and Lindsay screwed up. And she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat. Googling suicide. Googling drugs. Googling side effects. Googling ketamine treatments. Googling all of these drugs. Googling the effects of Tufts medications. Lorazepam, sertraline, hydroxyzine, lorazepam, Listerone, lorazepam, Listerone, trazodone, fluoxetine, zolpidem, murdazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. We have the chat, we have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in a house with a husband and her babies, respected nurse, wife, friend, mother. Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. Put that over in the bad pile. Right here. We spent all that time showing through Dr. Lapasada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you have to play pool. I challenge you to tell this jury why we spent a week showing that she committed, as your witnesses
Counsel, address the jury, please.
said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Laposada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Laposada and says, wrapped. They were just wrapped. They weren't knotted because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Laposada said, yeah, I saw what you did. And she walked away like if the glove won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children to the point where he had to struggle. And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective. And it shows the manipulation. This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Laposada said, you're talking about 4 or 5 seconds, so somebody passes out. No, they got to have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement, her throat was crushed. You heard the 911 team. You draw the inference, whether or not there's a conversation about where the children are. I tried to kill myself, the kids are in the basement, all that. You determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty, and number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got the charges are before the court, you can sit there in the court, you can feel proud of yourself. Did you do a good investigation? You even know with this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Did they? Lousy investigation of this. Well, that's okay because she was guilty, and they put her in the hospital, and she's the evil woman who killed the 3 innocent kids, and they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. in the handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges and they're sitting outside the door, and they're gonna make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers. Remember Meg Collins? She came in this court, Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital, treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major surgery of her broken, crushed spine, vertebrae, rib, thyroid. Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you've heard evidence, comes out of surgery, they are delusional. You've had anesthesia. You've had think about having a tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there, paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine. And then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about was they had to have this big confabulation about, we're going to take her off the, the healthcare process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You heard the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no, they were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory, not mine. One of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolata gave it to her. So you have this evidence. You have evidence of sleep aids. You have evidence in the bag. Because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it. And we held it for 3.5 years. Anybody care about it? No. You had evidence that police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth. Second time around, hoping for a good birth, worrying about the child with the, what do you call it, I forget, where they rub the thing like. This woman lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking. You've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices? Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucinations. She didn't say command hallucinations. I heard voices. It was a male voice. Told me. You had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2, Mac, put him aside. You've got the other doctor as well. So Mac is why he was freaked out when I asked him where he stayed. And the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective, why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests and then go back at it again with Mack and with Halbrun. And she was cooperative. She was pleasant. She was friendly. She answered the questions, and she owned what she did. Huh? She never ran from anything. She's gone through evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. You're busy. Paul Zeisel was there, literally, in Brigham and Women's, because I called him. Because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel. I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of a humane feeling to try to help this young lady And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Tewksbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. He's a good kid. He's a beautiful soul. So you have Zizelle that has been with her all that time. You've got Sheila who's been with her all that time. You've got evidence that her mom and dad who lived in Connecticut come up and they stay and they visit with her and that they sit with her and God forbid they actually sometimes had dinner. Remember that? They got the Tewksbury records. Boy, there's a good score. Let's go through the Tewksbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly for 3.5 years. She's acting like a human being trying to exist. But they go through the records and they want to get those dates and use them against her. Manipulation. And then you consider we're 3 weeks away from a trial. The guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet she was cooperative. She was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records. She signs the HIPAA forms. They don't know what her records are, but they know for sure what Dr. Resnick had in his report. They know for sure what Dr. Zizelle had in his report. They know for sure what Meg Spinelli had in her report. And they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her. She passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate, and more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zizelle, Dr. Carney. And they were paid for their testimony. They're all paid, like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert. on the lingering. You heard him testify by Zoom because he had surgery. But he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them. Everyone says they look at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death, times 3. Has any of the government doctors rebutted that? One of them, Halbrand, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday, who didn't even know what killing during the course of the psychosis was. And when I was questioning him about it, he agreed. And I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why? The how? And the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect. As Dr. Zeisel said, that she was suffering from a disease or defect. As Dr. Condi said, she was suffering from a disease or defect. And Condi took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence. So you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied, according to the guy yesterday, she lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she was, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard-charging, manipulating woman that was controlling, and everything in their life was controlled, and she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi testified when asked, did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Callan, put down for a nap. Hopefully we'll nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then, that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I didn't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts. You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs. And like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote, to support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time that she killed her children. You all remember this. October. This is not an evidence, it's micro-identification. It's too big. So, but basically it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? That's manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callan, because she loved her children. They were her life. Manipulation. And when you consider the journals, I don't know, you watch the movie The Shining with Jack Nicholson. Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice one. She's testifying. She didn't know. I suggest to you that she didn't know hardly anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you get when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone. You don't measure going down the stairs. You measure stair climbing, right? That's what the testimony was. And there were 3 stairs that were climbed. Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross. What happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and it left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right? You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the bathing, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You'd think that that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live a life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was. Along with the fact it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. The burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. And I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot, there's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh no. Patrick said that the child was eating the chicken McNuggets in the bowl. No. She was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, you remember there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices, malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head. And it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
All right, Como.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue
medical reasons, justifiable reasons to understand, and this is very much more Alan's area than mine, but there might be very justifiable reasons why women could act in a bizarre way, not through evil intent, but because of some imbalance of the mind triggered by childbirth itself and pregnancy itself. And that's very much Alan's area that I know he will be able to deal with in great detail.
And before we get there, let me just ask you, you treat women who kill people within the first year as something called infanticide.
Yeah.
What is the difference between not murder? What is the difference? And also, you also will indict, I guess, generally, or if there's a coroner, I guess, you're a coroner, coroner's finding for manslaughter, not murder. So can you just tell us a little bit of the difference in England between those things than as you understand it in the United States? Because I know you're very familiar with U.S. law, having been before the UN and all on different cases.
The situation in the UK in terms of the effect of infanticide is that if a woman, by a willful act, or indeed by an omission, if, for example, they don't do something they need to do to maintain the child's life, but if that child is under the age of 12 months, if the balance of her mind was found to be disturbed, then that can be a defense to murder. Now, when we had a death penalty, that was really important because the fact that infanticide was an alternative finding that a court on the right facts could make, it meant that someone who was essentially suffering from a mental illness related to the pregnancy, it could be a totally temporary disorder of the mind, she could be spared being hung if it was found by the court that she was guilty of this new offence in 1938 of infanticide rather than murdering her infant. So it provided a defence. It saved the lives of women who were not acting with evil intent, but acting because the balance of their mind, in the old terminology, was disturbed by what we've now recognised as a perinatal illness. And Alan's very much a leading figure, a leading light in that particular area.
And I think, Alan, this is where you come in, perinatal psychiatrist. What is that? How did you get involved? And before the show, you were telling me about this being one of the most acute conditions that anyone could ever have and is untreated, especially when it's untreated. Can you talk to us a little bit?
Yeah, so I'm a perinatal psychiatrist, which is a recognized subspecialty of psychiatry in the UK and in a small number of other countries. And that's what I've practiced full time for the last 30 years. So I've only been looking after mothers and babies during pregnancy and the first year after the birth. And the illness of postpartum psychosis that you were mentioning earlier on is one, if not the most acutely severe, high-risk, complex illness that we see in the whole of psychiatry across the whole population, in that it can start very, very suddenly. So 1 minute a mum can be holding a baby, for example, seeming absolutely fine, joyful, and within an hour, she can be hearing voices, believing that somebody, believing, not thinking vaguely, but believing absolutely. It's almost impossible for us to imagine what this could be like, believing that somebody was going to get her, that the devil was after her, that her child was being poisoned, for example. And it's not many steps from that to believing that the best thing is to be disposing of yourself, to be killing yourself because there is no possible future, or indeed, very rarely, but well described internationally in every country of the world, the small risk that she might believe that actually the kindest thing to do for her child because of some horrific thing that's about to happen is to end the child's life. And this is a very well described phenomenon, and actually psychosis, where one believes, these are called delusions, where one believes absolutely something that is going on that isn't going on, can happen to anybody at any stage in their lives, but there is no time in human existence when you are at such high risk of this happening as in the first few days and weeks postnatally. And of course, that only happens to women who've just given birth. And we can predict some of the women who are at incredibly high risk of this happening, 50, 60, possibly even 70% risk of this happening. We can predict them several months in advance at the very beginning of pregnancy. And we've known this since the 1980s, and worldwide, including in the richest country in the world, we have done nothing systematically to protect those people. Now, if there was a cardiac problem that gave you a 50 to 70% risk of being extremely ill, with your life being at risk, even your children's life being at risk, and it happened in men, and you could predict the date when it was going to happen, I can tell you millions would be spent, and no part of the states, or indeed the world, would be in a situation where people were not protected from this. I think it's because it's women, and because it's women doing the most important thing for the future of humanity, and that's bringing on the next generation, we somehow think this is unimportant. And also because it's mental health. And worldwide, even in wealthy, supposedly advanced, and as you said, civilized countries in the world, we neglect mental health. And isn't that an extraordinary paradox? Because that's the thing that we hold most dear, is our mental functioning. You know, you wouldn't be doing what you're doing today if it weren't for your mental functioning. When I ask you how your children...
that may be a different story being a lawyer. But
but why don't we invest in it? You know, and if I ask you how your children are getting on, you don't tell me, oh, their liver function is terrific or their bone density is great. You say they're happy, they're getting on well with their friends, they're doing well at school. It's their mental functioning that we like, and yet we discriminate against it when it comes to investment. Extraordinary situation. And this is the absolute acute tip example of this iceberg.
Look, Dr. Allen, let me ask you a couple of questions. Two things you touched on that are going to be key to this trial underway in this courthouse behind me. One is this flip the switch kind of concept to psychosis, that it can be you're fine and then you're not. That's number one. Yeah. Number two, how far past giving birth does the study suggest these things can happen? I know you mentioned it seems like earlier rather than later, but we have a case here where it's 8 months post. That may be an issue. Thoughts on both of those things?
Well, really important distinction to be drawn between when the symptoms actually start appearing and when they are seen and recognized in the outside world by people, even highly trained, experienced experts. So the evidence that we have across the whole of mental illness, including psychosis, is that it takes a long time before it's recognized by the person themselves, because very often you just think you are you, and this is the world. You'll believe that this is what's really going on. So why would you think that you're mentally ill? And actually, that applies what we call lack of insight. This lack of understanding that one is unwell oneself applies across the whole of mental health problems, but certainly in postpartum psychosis.
Can I just interrupt you, doctor, and just ask you, why does it happen that you could appear fine an hour ago, and then as Michael Bryant says, the switch is flipped, and all of a sudden you're not fine? Why, and could it happen in 20 minutes or 10 minutes or 2 minutes?
Yeah. And we don't know why this is particularly a feature of postpartum psychosis, but it's well recognized that a very rapid onset, much more rapid than other psychiatric conditions and than other psychoses at other times. So this is one of the features. But another feature is women have an extraordinarily high level of fear that they're going to be judged. They may have a fear as part of the psychosis that they're going to be attacked in some way, but overwhelmingly their wish is to protect their child, and their fear that their child is going to be removed if they let on in the slightest. So even though they may be extraordinarily ill, hallucinating, deluded, unable to think clearly, there is that little bit of their mind that is still preserved, that is intent upon hiding this. And so I have seen many women where it was just my gut feeling that this woman was ill to start with, because I just could not elicit anything from her. Or rather, it was her appearance. It was something about her eyes and the way she looked at me that I knew something was going on, but she didn't say a word about it. And then later discovered that she'd been extremely ill when she started to get better. And this is not an uncommon finding. The other thing is, you were asking, Michael, about can it go on? And yes, our Infanticide Act, since 1938, has recognized that these illnesses can go on certainly across the first year of the child's life. And particularly in those days when we didn't have effective treatments, which we do now, incidentally, if a woman can stay, if we can keep a woman alive, 100% cure rate from this illness. It may come back, but 100% cure rate, and not many conditions in psychiatry or physical health where you can guarantee that. But
how do you keep a woman alive? This is the problem here. We have it's
you need services,
and we have services that seem for psychiatrists or doctors or medical, but weren't talking to each other. Various drugs, possible overprescribing, and then places that wouldn't take her for treatment because she was overprescribed. So where pretend this is a plane crash, and for the little bit you know about this case or any case, where did we go wrong?
Well, you need systematic services available everywhere for the whole of the population, and joined up. So perinatal mental health services, which we now have established throughout the UK, wherever you live in the UK, you can get specialist care if you need it. That wasn't the case 10 years ago, but that's joined up with maternity care, so that maternity service professionals are trained to recognize these difficulties and know exactly where to go to get immediate, rapid help. And we're very lucky in the UK. We have a national health system. It has some disadvantages, but one of the great advantages is we can coordinate and manage care. And that doesn't mean things don't go wrong, but they're much less likely to. Just to come back to Michael's point about, can this happen? Can this recur? Can this happen at 8 months, at 9 months? Yes, absolutely. These illnesses, although you can achieve 100% cure rate, it can take a long time to get fully better, and women usually suffer for several months, even with effective treatment. So the very highest risk period will usually last just a few weeks, and then you have variable patches where you need consistent care, and if medication is not managed well, which means very sensitively, because taking this medication is really difficult, you need encouragement, you need support, and you need to be kept consistently on the right sort of medication to make sure, by somebody who knows you and has seen you when you've been unwell, who can recognize if you're starting to slip again and get that medication adjusted, make sure you're taking it correctly, that you're not getting confused about what you're taking. All of that requires skilled care. And of course, you've got wonderful individuals to do that in the US. You've got some of the leading practitioners in this field and researchers in this field, but coordinated care is with consistency and continuity of care is quite difficult to get in the US.
That's a great point. Let me follow up, and let me just say that Dr. Peter Dean, we have not been kicking him off the show and then bringing him back on and kicking him off. I'm assuming there's a little technical detail. Let me ask you this question, Peter, because I think you can probably comment on it as well. In contrasting what's going on in the UK versus here in the US, I've characterized the care that Lindsay Clancy got as a ship without anybody steering the thing, no rudder. And so she's starting at point A, where she's been diagnosed to some degree, heading toward wellness, and along the way, all of these branches flying off of as she's continuing to seek care, but nobody really with a plan.
Yeah.
Is that a U.S. thing, or do you have that issue in the UK as well?
It may be a US thing, and you will know the system there better than I. And I apologize for my sudden disappearances. I was frantically trying to listen to Alan and basically trying to reconnect myself to the system, thus proving that men occasionally can multitask as well, but not very efficiently. But I was listening very much to what Alan was saying, and I'd like to come back on a couple of those things that I would really support. But in terms of what you're saying, I think that overall charge and management, is it better, the same, or worse in the UK? I think it depends very much on where you are in the system and sometimes where you are from a postcode lottery point of view, because there have been changes in the NHS in recent years, not just in psychiatric care, usually advances in psychiatric care, but in general care, the way that the consultant-led system in hospitals has changed. When Alan and I were medical students years ago, people would be admitted to a firm led by one consultant. If they came back into a hospital after the emergency admission, they'd be readmitted under the same firm. So there would be continuity of care. I saw at close quarters what had happened in the service now, where different consultants would come in every few weeks and take on care of a patient that I was in and out of hospital visiting. And suddenly there were shifts, changes in patterns. This is general care rather than psychiatric care. But I think it depends very much on what Alan was saying, that there needs to be that consistency of care so that you get a joined up approach, a joined up treatment plan, and something that develops with people who know that patient. When you get patients, in a sense, passed from one doctor to another, you lose that continuity, you lose that prior knowledge of the patient, and you lose all of the benefits that the sort of care that Alan was describing provides for patients. But I'd also very much support what Alan was saying about the fact that these things can come on not just days or weeks after a birth, but many months later.
So let me ask you this, Peter, and Alan too. Have you seen other cases? I know that Alan's going to add the answer. Have you, as a coroner, in all of your years of practice, and know about other cases besides the Andrea Yates case, which people are aware of here in the United States, where women may be screaming for help, or maybe not screaming for help? No one's identified them. And there's a tragedy where they kill the children and they kill themselves. And the right reason I say the last part, and a question I want to know from Alan to continue on with that after you asked her, Peter, is you and I were discussing, Alan, before we came on the show, that would we feel the same way about Lindsay Clancy and her screaming for help, and the fact that we all think she had to do this because she had to have postpartum psychosis. Why else would you just kill your 3 kids and then jump out of the window? Is the fact that she paralyzed making us paying attention to this case and believe her? And would things be different if she was just sitting at home and her husband came home and her kids were there and she had killed those kids? So Peter, you first, and then if we can morph into Alan.
I have had a similar, in some circumstances, tragic situation many years ago. It's probably about 15, 16 years ago. Essentially, the first time it came to police attention initially was when a young lady in her early 20s, heavily pregnant with what turned out to be her 4th pregnancy, was found having jumped off the top of a multi-story car park. She was found dead on the pavement. The fall was actually witnessed, so it's confirmed that she wasn't thrown off, that she actually deliberately jumped off. When the police went to her home, they found that her 3 children were all tucked up in bed, all dead. 3 years, 2 years, and the youngest one, 11 months of age. The scene was particularly tragic, and as a coroner for 26 years, you see some very tragic situations, and this one was one that stayed with me because the children were tucked up in bed with their favourite toys. She'd drawn green hearts on them. There was lipstick on the foreheads where she'd kissed them all, and on the wall she'd written things like, "I've put them to bed with their bears, they love their bears." There was another comment that she wrote where she said on one of the walls, "I'm going to keep them safe." She'd written, "I love you" on the children, drawn these hearts on them, and she'd written rather poignantly, "A mother never abandons their children." She was clearly a devoted mother who for some reason, and we can only speculate what sort of intrusive delusions, what sort of threat she felt she and the children were under. But her response in that particular sad situation was to protect her children as she saw it in her delusional state by taking their lives in a way that she thought was caring, and then taking her own life so that as she saw it, she could be with them, protecting them. Now, that didn't go to any trial because she died in the fall. So that came to an inquest to try and piece together what had happened. But the sad thing is that in some ways she was functioning quite normally, objectively. There was CCTV of her returning the flat keys to her partner's address. There was quite normal functioning at some levels, but clearly a really deranged set of delusions at another level that led to this incredibly tragic outcome. So it can be, even the best will in the world, quite difficult in some situations to pick up, because the situation at moment A may not be the same situation that presents itself an hour, 2 hours later. So it can be difficult, but one of the biggest problems is actually the medical profession itself being aware of the significance and the intense danger that the situation can present. Puerperal psychosis, postpartum psychosis, is a medical emergency, and it really has to be treated as such. When I'm speaking as a non-psychiatrist, Alan is the expert in this area and the leading expert in this area, but it can come on late. I mean, the oldest child in the situation the youngest infant in the situation I was referring to was 11 months of age. So it can come on later, it can be masked, but it needs to be recognised and treated as the medical emergency that it is by the profession itself. And the service that Alan has set up is a gold standard, really, of how to do that.
So, Alan, I morphed into you as to the question I posed you, and then Peter asked, how do we identify and could women, and two, what causes that switch that could happen in a minute? So that's one of the things the prosecution here is saying. Well, she was fine. She was ordering dinner 20 minutes before. She sent her husband out, so she's clearly there was no problem with her. She was going about her normal duties.
Yeah. So I've seen lots of women who appear superficially well, and this does seem extraordinary. I absolutely acknowledge that. And people who have not been faced by this sort of presentation, and indeed who aren't experienced in seeing people with postpartum psychosis, I can totally understand that they would find this somewhat unbelievable. But I have seen women who have been able to hide with superficial functioning, such as getting dinner and the children appearing well dressed and being got to school or to, out for their walks or whatever. But at the same time, harboring absolutely horrific thoughts in their minds and teetering on the brink of some sort of catastrophe. And just to make the point that in most cases, that catastrophe is not the woman killing the children, but the woman killing herself. And both in the US and the UK, the main cause of postnatal deaths in women giving births is psychiatric causes of death, not physical causes of death. Suicide is the leading cause of postnatal death. And this is very rarely spoken about. And it's extraordinary that maternity services are exclusively physical healthcare services when you have that sort of statistic of maternal deaths. So it's women themselves who are usually the victims, but absolutely they can hide this. Why is the original onset so rapid? We don't know. But we do know that there are groups of women who are at particularly high risk, and we can detect that risk in advance, even when those women are well during pregnancy. And that is something that we ought to act on. One of the cases, Pete was talking about a case, one of the cases that really spurred the politicians into a degree of action was the case that Pete described. But another one was in the East End of London, where we both studied, a psychiatrist. This woman was a psychiatrist herself who had a known bipolar disorder, which is a severe recurring illness with episodes of being perfectly well, interspersed with episodes of psychosis, mania, and severe depressions. So this woman was a psychiatrist with a known bipolar disorder, became pregnant, and told her physicians about her bipolar disorder when she was being seen in relation to her pregnancy. And it is known that is one of the high risk groups that gives you a 50% risk of developing postpartum psychosis. Nothing was done to protect this woman, even though she herself was a psychiatrist working in the system, and she ended up killing her baby and killing herself whilst acutely ill postnatally. And there's a moving, sad, tragic photo taken of her. And in fact, I have a collection of these photos of women while they are psychotic, having photos taken, as you do when you have a recent or a new baby or a small child, holding the baby, smiling at the camera. But at the time, she was incredibly ill and on the brink of killing herself and her baby. And these photos, I sometimes show them in lectures of these smiling women. And I say, what do these photos have in common? And the audience says, well, they're all smiling. And in fact, that's not what they have in common. They're all psychotic, acutely ill, very high risk, in desperate need of treatment. Very, very extraordinary presentation. And you need expertise both to understand this and most importantly, to detect it. And we need to move on from the law onto good services to protect these women so they don't have to end up in any sort of legal or court situation. But what we must not do is, when things have gone desperately wrong, then punish them even more than the suffering they've already experienced, partly as a result of the neglect of the state.
Alan, let me ask you this question, which relates to the facts of this case and some of the unknowns in this case. Even the prosecution in their opening statement references Lindsay Clancy going out the window, not jumping out, diving out, hanging out, falling out, but described it as she went out the window. Now, when you hear about the seriousness of the injuries, the crushed vertebrae at the C level and at the T level, I don't know how it happened. So from a psychiatric standpoint, what does it tell you when you learn, how she went out that window? A dive, a hang, a jump. How does that factor into your analysis?
Yeah. So most people who kill themselves, complete suicide, so suicide is death, most people intend to die. And just that in itself is almost unimaginable. Imagine how bad things you'd have to think things were in your life for you to decide not only that you'd rather be dead, but that you are going to kill yourself. Can you put yourself in that situation? It's almost unimaginable. So very serious attempts that don't lead to death are almost certainly, such as I understand it, and I don't know the details of this case, but it sounds to me from your description like this was a pretty serious thing to happen, and she was lucky to get out of it alive. From the psychiatric point of view, I would say it's almost certain that she was intending to die. And for you to intend to die, you have to be severely disturbed in your mental state, suffering from a severe mental illness. There's no way around that.
Yeah. And you and Peter both mentioned the same word, Peter, a lot more intrusive thoughts. And that's, she was writing in her diary that she was having intrusive thoughts. Is that a code word for something, doctors, both Peter and Alan?
Yeah. So intrusive thoughts that the true meaning of intrusive thoughts are incredibly common. So all of us occasionally get a thought, an unwelcome thought. For example, you're walking along a cliff path and you think, oh, I might fall, or I might even jump, and, I've got to stay clear of the edge. That's kind of normal, and we just shrug it off. It passes very quickly. And intrusive thoughts from a pathological point of view are, for example, in depression or severe anxiety, you get those sorts of thoughts, but really, really frequently, and so frequently that it stops you thinking about anything else. And that's very common in postpartum depression, not psychosis, postpartum depression. And the sort of intrusive thinking that goes on in postpartum psychosis is what we psychiatrists call delusions. And that's not just thoughts, it's beliefs, where you 100% believe that the devil is coming to get you and is going to cut your head off. And can you imagine believing something? And that's a real case example. Can you imagine believing, you wouldn't sleep at night, you'd keep all the windows shut, and you'd be absolutely terrified because the devil can get through walls and so on. Is almost unimaginable. So that is a delusion, and that happens in psychosis. But it's commonly referred to by lay people and sufferers as an intrusive thought, or I was thinking, or I felt like. So all sorts of words are used, but these are delusions, is what we call them technically.
One of the practical difficulties at times as well for doctors and for all healthcare professionals in this situation is actually assessing suicide risk when you're sitting with a living patient, because it can be quite difficult to assess because it can vary in different circumstances. And certainly as someone who spent a lot of time assessing suicide risk for living people in custody, prisoners in custody, and a lot of people with psychiatric problems who wound up in custody, one of the problems was actually assessing the suicide risk, because at times people can feel very bleak but are not yet suicidal. At other times they may genuinely be suicidal but have enough insight to feel that, well, if I say I am, they're going to watch me more closely and I won't be able to kill myself. And then there may be another cohort of people who actually are not suicidal, but in some situations may feel that there is some gain to appearing to be suicidal. And it's trying to work out in which group that person that you're assessing can find themselves. One of the things that we were taught by one of the psychiatrists that lectured us when we were medical students many, many years ago was an idea of lack of future concept. If you ask people, do you ever feel like harming yourself? Well, actually, it's not uncommon if people feel low and depressed to feel like harming themselves. It can be important to explore what stops them doing it, and they may feel that relatives or others would suffer if they weren't there, and they're not ill enough yet to take their lives, and they feel that might stop them. The flip side of that coin is if they feel that their condition is such that they're harming people who love them, that can be a really dangerous progression. But getting an idea of what their concept of future is can be very helpful in terms of determining whether they are bleak and empty about the future, or whether they still see some future there. And it's part of that whole network of problems that present in these situations of trying to assess suicidal risk, because a lot of people who are quite significantly mentally ill or suffering from a fluctuating but severe mental health condition may have quite lucid intervals where it can be easy, if you don't really try and get under the skin of what's happening, to miss a significant mental health problem. And as we were saying earlier on, hopeful psychosis is very much in that category. And so assessing suicide risk can be difficult, but it's essential that it's done properly face-to-face rather than just on charts and scores, which I don't think are a particularly effective way of doing it. You need to be sitting with your patient and talking with them and exploring those aspects.
Just to add to that, in the case of postpartum psychosis, I mean, all of that is absolutely correct. It really is tricky, and charts and scores have been shown to be ineffective in predicting suicide risk. Clinical knowledge and experience is far more effective, and teamwork and knowing the patient. But in the case specifically of postpartum psychosis, this is such a high-risk illness that it has to be assumed from the get-go before you even undertake a risk interview or assess the situation. Just the knowledge that somebody is recovering from a postpartum psychosis puts them at fabulously high risk. And that's why you need to take this condition very, very seriously. And that's why most women, not all, but most women with a postpartum psychosis need admission to hospital in the most acute phase and need very careful continuity of care after, because otherwise they die, and a small proportion of their children, will be at risk of dying as a result of this illness. It's a very, very high risk illness, and I've been very lucky in my career. I've seen very few suicides amongst the women I've cared for, but I've been ultra cautious as part of my perinatal practice with postpartum psychosis. And lots of other things, lots of other conditions, you can actually work with the patient and take risks. But in psychosis, the patient is simply not in control of what's going on, and you cannot do a deal. You know, you have a president at the moment who's famous for doing deals. In this example, you cannot do a deal with somebody because they are not in control of their thinking at all.
Let me ask you both this, because you've touched on something that's really been a hot button topic for people watching this trial. This concept of, okay, maybe I've had suicidal ideations, maybe some intrusive thoughts, but I have no plan. You know, and so the healthcare provider will say, well, there's no plan, as if that determination tells them where they need to go next, or what they don't do, what they don't feel they're needing to do. The plan. Let me start with you, Peter. Is that something unique to the U.S.? How do you handle that distinction?
I wouldn't want to put too much weight on the absence of a plan as some measure of psychiatric good health, because people can change very quickly. They can also act on impulse. And in a situation where, as Alan absolutely rightly says, this person is not in control of their function, that can change very quickly. So I actually would feel much less confident in putting weight on the absence of a plan. The illness itself is so full of risk that I think Alan's default position is the correct one, that you've got to act as if there is a suicide risk here, even if the normal assessment that you do in a less acute psychiatric condition for a less acute psychiatric illness, you can do those risk assessments. Here Alan's absolutely spot on. You've just got to absolutely assume that high risk is there, and you have to treat this as a psychiatric emergency, but that involves recognizing it for what it is. And that's a big problem sometimes, even with healthcare professionals, recognizing the degree of risk, firstly what the condition is or what it is likely to be, and then remembering the degree of risk that's associated with it.
Yeah. And Alan,
that sounds far too reasonable. I'm sorry.
Yeah,
Michael's
the reasonable. So Alan, let me then ask you, going on with that, no plan, right? Okay, so she doesn't get treatment. She doesn't get admitted because she doesn't have a plan. I find that unbelievable. If you have ideations and you're having intrusive thoughts and all, and she's writing in journals, she needs help, and she's calling her mother. She actually asked her mother if she could sleep with her in the same bed. This is a grown woman, because she was scared. She was expressing fear, and her mother was coming back and expressing fear. Now, the prosecution has been done something which has really been pissing me off. Excuse my language, but just as a person who's practiced.
It's a medical term.
Yeah,
it is. I thought it was a legal term, but maybe you're right.
Covers both options.
Okay, but the prosecution would say, well, she was faking committing suicide because she had hesitation marks, by the way, on her arms and wrists. She coded twice, okay, after she jumped, but their hesitation marks, they're superficial, and so therefore she was pretending that she was going to kill herself, and her plan went wrong, and she ended up hurting herself. She just wanted to get away from her kids. And today it was slipped in that there was hesitation marks, but the judge won't allow what the interpretation of those hesitation marks mean. And you and I all know what they mean, hesitation marks. Talk to us about how this is a misrepresentation by the government, if you want to say hesitation marks aren't meaningful when you're talking about a woman who's got 3 kids, who's being treated for postpartum depression and clearly has some postpartum psychosis risk.
So just a question of language here, speaking from the UK, I'm not sure what you mean by hesitation marks.
Peter does, right?
Yeah,
Peter
does,
right?
Again, just with a coroner hat on, and also with a police surgeon, forensic medical examiner hat on, it's the sort of incisions, that the superficial cuts that you might make.
Deliberate self-harm.
But they can be interpreted in 2 ways. And often not correctly. They can be interpreted as, well, he doesn't really mean it, or she doesn't really mean it. But in fact, I have seen so many completed suicides who have not only evidence of old deliberate self-harm, but also in people who've never done self-harm before, but have killed themselves by either cutting their throats, their wrists, that there are a few tentative marks before they make the final big one. And it's not uncommon to
That you shall give to the court, and the jury, the matter now pending between the Commonwealth and the defendant, the bar shall be the truth, the whole truth, and nothing but the truth. So help you. Thank you. You may have a seat.
All right, good morning, sir. Hi, Ms. Sprague.
Thank you, Your Honor. Good morning.
Good morning.
So on Monday, I had asked you some questions about the Surface Pro that you and the defendant had in your home and had access to, and about whether you had looked at a site on suicide methods on August 22nd. If I could ask you, did you look at a site for suicide methods on August 23rd, 2022?
I don't believe so.
And I had also asked you on Monday about when you were leaving the home on the night of January 24th, 2023, your observations of Lindsay and the children. Do you recall that?
Yes.
And you had testified that you observed Dawson on the couch eating, I believe you said chicken nuggets and green beans. Is that correct?
Yeah.
Do you recall, if you're facing the couch, where he was on the couch?
If I were facing the couch, he would be to the right.
To the right, okay. And showing you a photograph of the living room where there are some bowls on the couch. Is that a fair and accurate depiction of how the couch looked that night?
Yeah.
We could have this photo marked.
All right, any objection?
No, close.
That may be admitted.
Now, as you're getting ready to leave the house to head out to get the takeout, did Lindsay say anything to you?
Nothing specific that I can recall, just other than maybe goodbye.
Do you recall something about discussing something about CVS with her?
Yeah.
Okay. And what did she say about CVS?
She wanted me to pick up some stool softener for Cora.
And she hadn't mentioned that earlier in the text, correct? And what was her date of birth?
December 24th, 2017.
Prior to getting married, did the defendant ever tell you she had taken psychiatric medication while in nursing school?
Not that I recall.
After having Cora, did the three of you move somewhere else?
Yeah, we moved to Duxbury,
And what was your address in Duxbury?
47 Summer Street.
And do you recall when you moved there?
I believe it was July 2018.
And where were you working at that time?
I was working for a startup called Automation Anywhere.
At some point in time, did you start working for Microsoft?
Yes,
And when was that?
May 2020.
And when you worked for Microsoft, did you go to an office or did you work from home?
I work from home.
And was that from 2020 onward that you worked from home?
No, I started working from home in 2018.
2018, okay. So from 2018 up until, let's say, 2023, you were working from home, is that correct?
Yes,
And did you have an office in your home which you worked out of?
eventually, yeah.
And where was that located?
In the basement.
And was that a finished basement?
Yes.
Going back to after Cora was born, do you recall the defendant having any physical issues after the birth?
Yeah.
And what were those?
I think there was a lot of tearing and she bled a lot.
Did it take her a while to recover physically?
I would say so, yeah.
Did she have maternity leave at that time?
Yes.
Where was she working?
Mass General Hospital.
And what was she doing there?
She's a labor and delivery nurse. Yeah.
Okay. And so after the 2 weeks of your paternity leave, the defendant was still on maternity leave, correct?
Yes.
Okay. And did she have to take any psychiatric medications at that time?
Not that I know of. She had a lot of anxiety, but
Okay. So you're saying that she had some anxiety at that time. Is that correct?
Yeah.
How did that manifest, or how did you know that?
she just really struggled with the date of going back to work.
So immediately after having Cora, as she healed physically, what was her mood like when you're both on leave?
It was great. It was good.
Good. Okay.
I mean, relatively, yeah.
And so did the anxiety start as it became closer in time to when she had to go back to work?
Yes.
How many shifts was she working at that time?
Before Cora was born, she was working at least 40 hours, maybe more. After she went back to work, it was, I think, initially just one.
One shift?
Yeah.
And was that a 12-hour shift?
It was per diem.
Per diem.
And then she eventually did 2 shifts.
Okay.
I think it was 20 weeks.
After 20 weeks, she moved to 2 shifts?
I'm sorry, it was 20 hours a week.
20 hours a week, okay. And so from the time she worked her way back up to 20 hours a week at work until she had your next child, did it remain that 20 hours per week that she worked?
Pretty much, yeah.
And did you have any assistance in the home during that time after she went back to work? A nanny or a babysitter?
Yeah, we had babysitters. We had a babysitter who came probably 12 hours a week.
And did that typically happen after your wife had a shift, that the nanny or the babysitter would be there?
Yeah, so she could sleep.
Did the defendant work overnights?
Yeah.
And how long did you have that nanny or babysitter for?
Several years.
Do you remember her name?
We called her Miss Jen
Miss Jen? Do you remember her last name?
Shanahan.
And then you had a second child, is that correct?
Yes,
And what was their name?
Dawson.
And what was Dawson's date of birth?
September 30th, 2019.
And was Miss Jen still helping out in the home at that time?
Yeah.
And what was Dawson's delivery like?
Pretty traumatic.
How so?
He was in I think a breech position. So he came out in I guess I don't know much about it, but not an ideal way. And it caused just significant bruising and tearing.
So again, did the defendant with this second pregnancy have some pain and difficulty physically healing from the birth?
Yeah, much more so than Cora.
Okay. And was she on maternity leave at that time?
Yes.
How many weeks leave did she have at that time?
I don't recall, but I think it was more than the, traditional 12. I want to say it was 13 or 14, maybe more.
Page 13, if I may approach.
You may.
You don't have to keep telling me the pages, that's okay.
I could have you look at page 13 and just read yourselves lines 6 through 10, and then just look up when you're finished. Thank you. Does that refresh your memory as to how much maternity leave the defendant had after Dawson's birth?
Yeah.
And what was it?
18.
18 weeks?
Mhm.
Is that correct?
I believe so.
Okay. And, after dealing with the physical pain of birth and starting to heal, how was her demeanor and experience during that maternity leave?
I think it was fine at first. It was always when she had to go back to work, that's when she struggled. So,
Okay. So that was a pattern that you saw after
Yeah.
the baby, maternity leave was good, and then she'd struggle going back to work?
she just had a really hard time being separated from them.
What was the plan for how many shifts she would work or how many hours she would work after Dawson was born?
I believe it was the same thing.
And in terms of Ms. Shanahan, the babysitter, you had mentioned before that she was there about 12 hours a week. Did that stay consistent after Dawson's birth, or was it more or less?
Probably consistent.
After Dawson's birth, did the defendant ever tell you whether she was on any psychiatric medication after Dawson's birth?
No.
Did she seek treatment or tell you she sought treatment after Dawson's birth?
Yeah, she got a therapist for a short period of time, but it didn't last very long.
Did she tell you that at the time or later?
At the time.
Okay. And did she have any psychiatric hospitalizations or commitments at that time?
No.
What about after Cora's birth? Any psychiatric hospitalizations or treatments?
No.
Was there a time after Dawson's birth where she wanted to declutter your garage?
Maybe at some point.
Okay.
Yeah.
And did you assist her with that?
Yeah.
Okay. And how was that done?
We had a lot of stuff to throw away. And I think we sold some stuff on Facebook Marketplace. We just had a lot of stuff.
So did the two of you go through the items in the garage and organize it into what you would keep, what you would throw away, and what you would sell?
Yes.
And so it was very organized?
I would say so, yeah.
And you finished the project, is that correct?
It was always ongoing.
Now, eventually you had your third child, correct?
Yeah.
And what was their name?
Callan,
And what was his date of birth?
May 26th, 2022.
Can you describe that delivery for us?
It was great. From what I could tell, it was relatively quick. It was during the day. We were both smiling after, and I don't think there was as much physical trauma.
Nothing compared to what happened with Cora or Dawson, is that correct?
Correct.
Did the defendant have maternity leave after Callan's birth?
Yeah.
And how long was that leave?
She never went back.
How long was it planned for initially?
I want to say 18 weeks.
And were you on paternity leave as well?
Yes.
And how long was your paternity leave?
12 weeks.
So with Callan being born on May 26, 2022, the two of you were home with the children that summer on leave, is that correct?
Yeah.
What was family life like during that time period, those summer months?
It was great. We had a lot of time off. I was able to spend a lot of time with, I spent a lot of time with Cora and Dawson. So I would take them around, the playgrounds and birthday parties and stuff like that.
Okay. And what would Lindsay be doing while you were with Cora and Dawson?
Sometimes she'd come with us with Callan, but oftentimes we did kind of like a divide and conquer. So she'd be home with Callan and I'd be out with the older kids.
And what types of family activities did you all do during those summer months?
We went on a couple vacations. We went to the beach. We went out on our boat and went to friends' houses.
During those months, when you're going to the beach and out on the boat and visiting with friends, were there any signs of anxiety in the defendant during those months?
I would say starting in September, yes, but in the previous months, not so much.
When had she been scheduled to go back to work?
I don't remember the exact date, but I think it was October.
Okay. So again, it was that pattern of as it became closer in time to go back to work,
Yeah.
she started to struggle?
Yeah.
During the times when she would get anxious, when it was time to go back to work and she would start being anxious, did you ever have any difficulty understanding her when she spoke?
No.
And did she ever exhibit any behavior that made you concerned enough to call a doctor or want to commit her?
No.
When she was showing this anxiety, what were you seeing in her behavior?
Just a lot of stress. There were days where she had all three kids and, there's different nap schedules and different needs. So it was just really stressful.
Okay. And you're still working in the basement office at this point after Callan's born, correct?
I went back to work late August.
Okay. And when you work downstairs, how often would you come upstairs during the day?
All the time for lunch or just to say hi.
Were there times when Lindsay would ask you to hold the baby in the office while she was doing something?
So, yeah.
Okay. And were there times when you would watch one or more of the children while she took another to a doctor's appointment or to an errand or something like that.
Yeah, if it worked out with the schedule, yeah.
Okay. What was the plan in terms of how many shifts or hours she was going to work after Callan?
I believe the plan was 2 shifts per week, but there's a lot of flexibility. She could have done really anything.
Do you recall saying previously that that you were going to start off with 1 shift and hopefully move to 2?
I could imagine, yeah.
Okay. And you said there were some options, correct? What were those options if that didn't work out?
Well, I always put money aside in basically our own maternity account, just so that if she needed more flexibility, we planned for that. So
if she needed more time off, more than what her work would provide for her, you were financially secure enough to afford that at that
Yes.
time. During this time, in the fall of 2022, were Cora and Dawson attending preschool?
yes,
And where was that?
Learning Sprouts,
And where is Learning Sprouts located?
Duxbury.
How often were they attending Learning Sprouts?
Full days Monday, Wednesday, Friday, and a half day on Thursday.
And what was a full day? What hours?
I think it was 9 to 4.
9 a.m. to 4 p.m.?
I think so, yeah.
And what was a half day?
9 to 12:30. I think they might have had some days where they started early. I can't remember.
But basically all day, working hours all day, Monday, Wednesday, Friday, and then the mornings on Thursday. Is that right?
Right.
And who would do drop-offs for school?
We both would.
And what about pickups?
Both of us.
Together or take turns?
Usually we would take turns.
Now, at some point in time after Callan was born, did you hire a nanny?
Yes.
And when was that?
I think it was in August or September.
Of 2022?
Yeah.
And who was that nanny?
Lainey. I don't remember her last name.
Was Elaine Rossi sound familiar?
Yeah.
And do you recall how many days per week Elaine was going to work when you hired her?
I think it was 12 hours.
But it wouldn't be 12 hours altogether. It would be spread out over the week. Is that right?
Correct.
And who was she hired to take care of?
Everyone. But mainly it was going to be Callan.
Because Cora and Dawson would be at school?
For the most part, yeah.
And what was the plan for when Elaine would work? Was it that same type of after Lindsay worked shifts or something different?
Yeah, the goal was after Lindsay would work. I mean, she never went back to work, but I think we wanted to get her just like oriented with our house and the kids. So we had her start before, and then she was amazing. She was an amazing caregiver, but eventually we decided to let her go because Lindsay was home anyways.
So when you initially hired her in August or September, you said Lindsay was going back to work in October. So is that what you're talking about, that give her that month or so, give Elaine that month or so to get situated and acclimated to the house?
Yeah.
Okay. Have the kids get used to her. Is that right?
Yep.
Okay. Did she also do some cleaning, laundry, and food prep?
Yeah. Yeah, she was amazing.
Now, during this time frame, and again in the end of summer, fall period of 2022, what types of activities were Cora and Dawson doing?
Gymnastics. Are you talking about organized activities or just in general?
Organized.
I only remember gymnastics.
Did they both do the gymnastics?
Yeah.
And then were they also participating, maybe not in organized situations, but in swimming, soccer, skiing, things like that?
Yeah, they were doing swimming. And yeah, Cora and Dawson did skiing. Yeah, Cora started doing soccer. She didn't really like it, but did a little bit.
And who took them skiing?
I did.
And as in terms of the swimming, where would you do that?
We did it at Goldfish in Rockland, I think. And then Lindsay took them somewhere in, I think, Plymouth. I don't remember where it was.
So you would each take them swimming at various times?
Yeah.
Okay. Did you also do some swimming at the Kingsbury Club?
Yes.
And what is the Kingsbury Club?
It's like a gym with a pool, and they had childcare, so sometimes they would hang out in the kids' room and we would go work out.
And is that in Duxbury?
It's on the Kingston-Duxbury line. I'm not entirely sure, but yeah.
Okay. And so you could drop the kids off at the daycare portion and go work out or swim or something like that?
Yeah, or we could go with them and go swimming.
Okay. Did Lindsay work out?
Yes,
She was very health conscious?
I think so.
And were you aware that she had been an athlete in both high school and college?
Yes.
Do you recall what she did?
Competitive cheerleading.
Now, when you were together, what type of exercise would she do or did she prefer?
She did a lot of running. She did the Peloton, and she did it was like some program called Beachbody, I think.
Do you recall when she started Beachbody?
Maybe in the spring of 2022. I'm not sure.
So right before having Callan, would that be accurate?
Probably, yeah.
When you returned to work, and you said that was in August, correct?
Yes.
What was the defendant's demeanor when you returned to work?
Increased anxiety and definitely, stressed out.
Do you recall describing her as slightly stressed but in good spirits?
Yeah.
And when she was stressed out, when she was showing some anxiety, how did that manifest?
I don't really know how to describe it. I guess it's just any way you can tell that somebody's stressed out. And I don't know, she would say, I'm not looking forward to going back to work. I remember once she said it's just so unnatural to be separated from your newborn, stuff like that.
So she didn't want to go back to work? Is that what you're saying?
I think she did. It was just a really difficult transition for her.
And do you recall attending a wedding on September 17th, 2022?
Yeah.
And where was that wedding?
New Hampshire.
Was it just you and Lindsay that went, or did the whole family go?
We brought Callan.
And when you were at that wedding, do you recall having a conversation with Lindsay about medication?
Yes.
What did she say to you?
We were walking downtown and she said, I think I'm going to start taking Zoloft.
And did she tell you why she wanted to start taking Zoloft?
She said, I think it's really going to help with my anxiety and with going back to work.
And did she tell you how she was going to go about getting Zoloft?
Yeah, I asked her, how are you going to get Zoloft? It's a prescription. And she said, usually just ask the doctor and they'll give it to you.
And did she tell you that she was going to see a psychiatrist?
Yeah, I believe so.
And when she did that, did she tell you who she was going to see?
No.
Did you eventually learn the name of the person who she went to see?
Months later, yeah.
Okay. And who was that?
Jennifer Tufts.
Okay. And did Lindsay tell you when she started seeing Dr. Jennifer Tufts?
No.
Did you learn, or strike that, did Lindsay tell you when she received the medication and when she started it?
No. I should correct that. It's not exactly.
Well, let me just ask a question first.
Sure.
When did you have a conversation with Lindsay about the medication she was on?
Eventually, yeah, but I didn't know the start date.
Okay. And so when did this conversation take place, this eventual conversation?
Probably the end of October.
Okay. And at that point, what did Lindsay tell you about the medication and how she was taking it?
I don't remember exactly, but I learned that she was taking the Zoloft, and I don't remember really too much about it after that. She was just taking it, and we were seeing how it went.
And did you notice any changes in her physically during that time frame that she was on it and you weren't aware she was on it?
At the time, no, I don't think I did.
And did you notice any changes in her emotionally during that time when she was on it, but you weren't aware she was on it?
Yeah, she wasn't really improving. She just kind of seemed to be gradually becoming more in like a depressed state.
And how was that manifesting? What were you noticing?
It was just small things. I was planning a trip with Cora to San Francisco, and she was nervous about us going. And I remember we went to a Halloween event, and just leading up to it, I remember it just kind of seemed like she didn't want to go for some reason.
Okay. Now, do you recall learning that she had actually obtained the prescription the day before she told you she was going to ask for the prescription?
I did later learn that, yeah.
So she's telling you at the wedding that she is going to ask to take this medication and going to see a psychiatrist to get on that medication, but she actually already had the prescription. Is that correct?
Correct. I don't think she started taking it yet, but she already had it.
Okay. And did Lindsay tell you how long she took the medication for?
She may have. I don't remember the exact time frame. I just remember she took it for a period of time, and then her sleep started to suffer, so she stopped taking it.
And did she tell you whether or not she spoke to her provider, her doctor, about the troubles she was having?
I believe so, yeah.
Okay. And did Lindsay tell you that she was advised to double the dose of the Zoloft?
She may have. I don't remember.
Page 31. You could look at lines 20 to 22, and then just look up when you're
Sure.
finished.
Okay, yeah, apparently she did.
Did that refresh your memory?
Yeah.
And so did Lindsay tell you that she was supposed to double the dose?
I guess she did, yeah.
Did you notice any changes in her sleep during that time when she was on the medication, but you weren't aware she was on it?
Eventually, yeah.
When was that?
I don't remember the exact dates. But she just, one night she said, do you mind? She started it by saying, I'm not mad or anything, but do you mind sleeping in the basement? And letting me just sleep in our room with Callan. And then you can take the monitors down in the basement. And if Cora and Dawson get up, you can get up with them. She said, I've just been having a lot of trouble sleeping. And I'm hoping that like if there's less in and out, then there'll be less disruption.
Okay. Had you noticed prior to her telling you this that she was up a lot or having trouble sleeping, like physically seeing her awake?
No, not that I recall.
And did you in fact start sleeping in the basement for a period of time?
I think I did it for like 2 nights, and then she actually went down in the basement.
Okay, so then you went back up to your bedroom to sleep, is that correct?
Yeah.
And how long did Lindsay sleep in the basement for after that?
Maybe a couple weeks.
And so during that time frame, was she telling you that she was still having trouble sleeping?
Yes.
But you weren't actually down there watching her sleep. You're getting this information from her, correct?
Correct.
Were you aware that out of the Zoloft prescription she was given, she only took 7 pills?
No.
After you had the conversation with Lindsay where she said she was going to double the dose of Zoloft, did you notice any difference in her demeanor or behavior?
I would say yes. I don't know if I connected it with the doubling of her Zoloft, but over that period of time, she just kept getting worse and worse.
And what period of time was that? What month are we in?
Mid-October to the end of December.
Okay, so she got the prescription in September, started taking it in October, took 7 pills, but was having difficulty in December. Is that what you're saying?
Yes.
From this medication?
Yep. Well, I don't know which medication it was from, but yeah.
Okay. At some point in time, did Lindsay switch providers?
Yes.
And why did she do that?
Because whatever she was doing with Jennifer Tufts, it wasn't working. She was only getting worse. And she thought that it would be better if she worked with, I guess, more like a perinatal psychiatrist.
And did she get a referral or a recommendation of where to go?
I think so, yeah.
Do you know who gave her that recommendation?
It might have been my mother.
And your mother's a nurse at South Shore Hospital, correct?
Yeah.
Does she also do labor and delivery work?
Yes.
Okay. And so do you know which provider or which office she recommended?
Yeah, her name is Julie Paul.
And was she at the South Shore Perinatal Clinic?
Something like that, yeah.
Okay. And do you know when that was?
I don't know the dates on that.
Do you recall saying previously that it was towards the end of November?
Yeah, that sounds accurate, yeah.
Okay. And you said she initially saw someone named Julie Paul, is that correct?
Correct.
Okay. And do you know how long she saw Julie Paul at that facility?
I think it was only 4 or 5 days.
And were you aware that Julie Paul left that office?
Yes.
And do you know who Lindsay saw after Julie Paul?
Rebecca Gelata.
And was Rebecca Gelata a nurse practitioner?
Yes.
Were you aware that she also saw a licensed social worker therapist named Letitia Dukes while she was at the South Shore Perinatal Clinic?
I don't recall Letitia Dukes, but it's possible.
So Lindsay never told you that she had therapy sessions with a person named Letitia Dukes during that time frame?
I don't remember any therapy sessions now.
Okay. After switching to Julie Paul and then Rebecca Gelata, did Lindsay start coming home with different prescription bottles?
Yes.
Okay. And were some of these medications that she came home with, were some of them during the time she was with Dr. Tufts?
I think some of them were, yeah.
And some of them were while she was with Julie Paul, is that correct?
Correct.
And then some while she was with nurse practitioner Gelata, is that correct?
Yes.
Okay. And would it be accurate to state that you provided the district attorney's office with a printout from CVS Pharmacy of all the prescriptions that were filled for Lindsay from September through January, September 2022 through January of 2023.
Yes.
Any objection?
No, of course not.
I'd ask for it to be admitted as
Sure,
one.
yeah. In members of the jury, one of the things I forgot to tell you is anything that's entered as an exhibit, you'll have with you in the deliberating room when you're deliberating. So you'll have a chance to go over that as well. So you'll have anything that's marked as an exhibit. Okay. Thank you.
Now, while she was taking these medications, the various pills, were you always with her, watching and monitoring exactly what she took?
Not always, no.
Sometimes you'd see it, sometimes you wouldn't.
Yeah.
Directing your attention to February 6th, 2023, did you go to the district attorney's office and, or have your attorney go there and provide a bag of prescription medication that had belonged to Lindsay?
Yeah. I think the police took a bag of prescription medications that night, the night my kids passed away.
Mhm.
And then there was a bag that I had in my truck that I was supposed to, nurse practitioner Charlotta said you can bring them to like a police station. They get rid of them for you. But I never got around to it.
And where had you stored those in your truck?
In the center console. It's like underneath the center console that opens.
You have one of those center consoles that open up, but then there's another larger
Correct.
compartment below it?
Yeah.
So was it your plan to bring these to a location where they could be properly disposed?
Yeah, I didn't want to just throw them in the trash. So
And these were all medications that had been prescribed in the past to Lindsay, but she was no longer taking, correct?
right.
Your Honor, I don't think I have any objection to any of their exhibits, so
Okay.
she doesn't have to keep showing it to me. That's
All right.
fine.
So I'll assume if you do have an objection, just
Sure.
rise, let me know. Okay, thank you.
So for the record, a bag here with 9 pill bottles as exhibit 2, please.
Thank you.
And so looking in exhibit 2, we have the Zoloft that was prescribed by Dr. Tufts and filled on September 15th, 2022. And I think I asked you earlier, you weren't aware that only 7 pills were taken out of this, correct?
That's correct.
And then there's another prescription in here for Ativan that was filled on October 26, 2022. Were you aware that only 6 pills were taken out of that bottle?
Can you say the date again?
October 26, 2022.
And how many did it start with?
Let's see. Um, 30 pills.
Okay. I mean, I don't have those exact numbers on how many she took, but there were adjustments made on the dosage of the Ativan.
Mhm.
So that aligns with
But
what
the
happened.
question was, were you aware that only 6 pills were taken out of this prescription?
No, but I think the context is important.
Okay. Were you aware that there was a prescription for buspirone or Buspar filled on October 26, 2022, in which only 2 pills were taken out of the 30 that were prescribed?
I found out about the Buspar later, and I didn't know about the number of pills taken.
And then were you aware that there was a prescription for hydroxynine, prescription filled on October 26, 2022 For 30 pills, and that only 3 pills were taken out of this bottle.
Which
Hydroxyzine.
yeah, what is that?
I believe it's in some type of, similar to an antihistamine, like Benadryl or something like that.
Oh, okay. I don't really recall much about that drug.
Okay. And were you aware in this bag there was another prescription for Buspar that was filled on November 9th, 2022, 30 pills prescribed, and no pills were taken out of this bottle. Were you aware of that?
I wasn't keeping track of the number of pills taken out of each bottle.
Okay.
So
And then just ask you about one more, the trazodone prescribed on November 16th, 2022 by a doctor from South Shore Hospital, 30 pills. Were you aware that only 7.5 pills were taken out of this prescription?
No.
So there were a lot of pills prescribed, but not a lot of pills taken, correct?
is that comprehensive of all the pills that were prescribed?
These are the pills that you brought into the police station. So out of these,
Out of those, yeah, it's possible that not a lot were taken.
do you recall what was the most amount of pills prescribed? I guess I could ask this better. What was the maximum number of medications she was on at any one time?
I want to say 3 or 4.
Okay. Would it surprise you to know that she, at any given time, the most she was prescribed was 3, but most of the time it was 2 medications that she was prescribed at any given time?
It wouldn't be terribly surprising, no.
Now, on November 16th, 2022, did Lindsay visit South Shore Hospital?
Yes.
Okay. And why did she go to the South Shore Hospital that day?
I believe that day it was because she basically went 48 hours without sleeping.
And was she having heart palpitations?
I think so, yeah.
Were you aware that she had taken a weed gummy that day?
I don't recall.
And are you aware that she didn't tell medical staff at the hospital when describing her symptoms and her medication that she left out that she had used marijuana?
I wasn't with her, so I don't know what she talked about at the hospital.
So she drove herself to the hospital?
She did.
And she drove herself home from the hospital then, is that
Yeah.
correct? Now, during this time frame between September and November of 2022, are you still participating in activities as a family?
Between November and December?
Between September and November?
Yeah.
Okay. And what types of things were you doing?
We celebrated Halloween. I don't really remember what else, but I think we were doing things regularly.
Do you recall going to an event with food trucks?
Yeah.
And do you recall going to an event in November where there were trains to ride with the kids?
Yeah.
So we have the photo from the food truck event. This is exhibit 3. And the photo from the train event is exhibit 4. 3 and 4 somewhere. Can I publish?
You may.
So exhibit 3 is this Lindsay, Cora, and Callan at that event.
Yeah.
And exhibit 4 This Lindsay with all 3 kids at that event in November.
Yeah.
Did you have plans for Thanksgiving that year?
Yeah.
What were your plans?
I believe the order was we went to Wallingford where her parents lived in the week before, and then the week after we went to my sister's house.
And where did your sister live? What town?
South Hamilton.
And that was a week after Thanksgiving, is that right, correct?
I think so, yeah. Yeah, it was.
And is this a photo from Thanksgiving at your sister's house?
Yes.
I could have this photo marked as exhibit 5, I believe.
Right, that may be marked.
5. Showing you what's been marked. Exhibit 5. Is this Lindsay here on the left?
Yes.
And are those your sisters in the photo with her?
That's one of my sisters and my sister-in-law.
Okay. And have they coordinated outfits for the day? The shirts?
Yeah, I think my sister did.
What was Lindsay's demeanor that day?
She was in rough shape.
Rough shape?
Yeah.
How so?
She wasn't talking much. She had low energy. She was really depressed. I just remember when she showed up, my sister-in-law gave her a big hug.
And she was able to get through dinner, eat dinner with everyone?
Yeah.
Okay. She interacted with people, is that correct?
I would say very little, but to some degree, sure.
And she took care of the kids with you while she was there?
We both took care of the kids together.
You mentioned earlier that your wedding anniversary is in December, is that correct?
Yeah.
Okay. Do you recall going out for your anniversary on December 3rd, 2022, going into Boston?
No, we didn't go out.
You don't recall arranging for a massage for Lindsay and then going to the Omni Parker house and going out to dinner that night?
No, December 3rd, 2022, we stayed home.
You stayed home, okay. Showing you a photo of you and Lindsay. Do you recognize this photo?
Yeah.
And when was that taken?
I'm not really sure.
It wasn't taken on December 3rd when you were out celebrating your anniversaries?
In 2022?
Yes.
No. No, we wanted to go out, but we canceled because she wasn't feeling well. So we stayed home. We got takeout.
Okay. Did you also, on November 26th, 2022, go out as a family to get a Christmas tree?
Yes. Well, probably. I don't know. But yeah, around that time, yes.
Okay. suicide methods on August 22nd. If I could ask you, did you look at a site for suicide methods on August 23rd, 2022?
I don't believe so.
And I had also asked you on Monday about when you were leaving the home on the night of January 24th, 2023, your observations of Lindsay and the children. Do you recall that?
Yes.
And you had testified that you observed Dawson on the couch eating, I believe you said chicken nuggets and green beans. Is that correct?
Yeah.
Do you recall, if you're facing the couch, where he was on the couch?
If I were facing the couch, he'd be to the right.
To the right, okay. And showing you a photograph of the living room where there are some bowls on the couch. Is that a fair and accurate depiction of how the couch looked that night?
Yeah.
We could have this photo marked as connected to
All
this.
right. Any objection? That may be admitted.
Now, as you're getting ready to leave the house to head out to get the takeout, did Lindsay say anything to you?
Nothing specific that I can recall, other than maybe goodbye.
Do you recall something about discussing something about CVS with her?
Yeah.
Okay. And what did she say about CVS?
She wanted me to pick up some stool softener for Cora.
And she hadn't mentioned that earlier in the text, correct?
Yeah, I don't think so.
So as you're leaving, she asked you to make a second or another stop while you're out. Is that correct?
Correct.
Okay. And in response to that request, did you ask her to do something?
I don't remember.
I could show you page 77, lines 23 and 24, if you could just read those to yourself.
Yeah, I told her to text it to me, which she did.
I'm sorry, so that refresh your memory and
Yep.
ask her to text it to you?
Yep.
And did she do so?
She did.
And was that at approximately 5:15 p.m. that she texted PDLX?
Sounds correct.
Okay, sorry to bump Patrick off the stage there, but interestingly, and I'm glad we were able to put that up and get folks kind of back into that. So it was like 4+ weeks ago, right? We're going to have a little demonstration on our 6 o'clock tonight, and it relates to his testimony. I'm going to look at it again to make sure we have the right little moment where he's talking about finding the children and the bands and what that all looked like. And then we'll have our own little demonstration to, you know, mash that up with his testimony, because I think it's one of the biggest issues, partner, in this case, and that is the Commonwealth suggesting they were just floppy loose around the neck, and therefore Lindsay Clancy must have had those ligatures held manually in place for minutes and minutes and minutes, whereas I think between friction and a half knot, as described by Patrick Clancy, you hold it for about 4 or 6 seconds till they lose consciousness, then you can walk away and the friction maintains that constricture.
Right.
I think that's worth pursuing. So we'll look at that tonight. Okay, here's what happened, and then we'll get out of your way, folks. Let you take a breather before we circle back at 6.
We have a few start comments, which I'll get to.
Okay,
One of
good.
them's a
And we have
question you
Mark
have to
Bettero
answer.
coming on tonight to share his
Yeah.
thoughts as well. So they just had us go back into court just to officially, say thanks, jury, for your efforts. Take the rest of the night off. We'll see you tomorrow. Don't talk to anybody. Don't do anything. Blah, blah, blah. So let me correct my miscount. There are 9 women, not 8.
Okay.
And here's where I think I went wrong. I think it was wishful thinking. Dapper Dan is out.
Oh, you've lost
Yeah.
Dapper Dan to
He-
9 women.
And I
9 women,
know
okay.
that he, because of the way he dressed and acted every day, that he was taking this very seriously.
Yeah.
So we'll see, if tomorrow as an alt, he comes in a T-shirt and flip-flops. I don't know. But that was my one error. I had included him in the
Okay,
jury. Like
so
I said,
that's why,
probably
okay.
subconscious.
Sorry
wish-
about that, chat. And we'll
Yeah.
put a notice in the chat. 9
Yeah,
women.
take it out of my pay.
Yeah.
So,
That's hard
anyway,
to do.
they all seem, a little bit tired. It's a long day. It's a very eventful day. But Grandma was doing. I think I may change her name. I may audibilize. The more I look at her and see her, Ruth Bader Ginsburg.
Oh,
I'm
she looks
telling
like
you.
Ruth Bader Ginsburg,
Yes.
really? Wow.
About that same size, very petite. Wears her hair back in a bun. So I may change her name and audibilize, because I think when she surfaces, if she does, whether it be here, there, or somewhere else, people are going to go, oh, she really does look like Ruth Bader Ginsburg. So
Okay.
she was nodding along with the judge, like they were having a conversation, about what needs to be done, and here's what you'll do tomorrow, and thanks for all your hard work.
We
and all
missed
that.
it. We missed the feed. What did the judge tell them?
Really just, we're going to wrap it for the day. You guys come back at 9:00 tomorrow. You'll meet in the courtroom at 9. He'll ask those same questions. Have you done anything, seen anybody,
Right.
blah, blah, blah. Warned them again about not doing this. Don't even talk about it. Same admonitions, but a little more important at this point, since, you're in the midst of it. And they had,
Will he be bringing the alternates in when he does that? Did he say?
I expect, because they're sequestered, by that I mean separated, not
Right.
truly sequestered. They're in a different room somewhere. So they come in, and now they have them. Those who weren't moved, meaning as an alt, are in their same seats pretty much, but then the others have kind of contracted, telescope down, so that all the 12 seats are filled, and the 6 alts are all on the side. If you're looking at the jury box, the 6 alts are on the far right side, grouped together. So
Okay.
little mix up there from what it has been for the last 5 weeks. So
Did you see the alternates? Were they brought back in court now?
yeah.
How did they look? Were they looking
Dapper-
happy? Were they
I'm sorry,
smiling?
Dapper Dan looked down. I don't know. Again, maybe I'm just reading into it, but he just looked, down.
And you never know
So-
what happens in a jury deliberation.
No.
Were they
and
serious? Were any of them smiling? They all were serious. I
there were a
assume.
lot of nodding, a lot of just pleasant. They didn't. Nobody seemed to be dragging per se. Just like at the end of a day versus the beginning of a day.
Mhm.
And other than Ruth Bader Ginsburg, who was really engaging with the judge as he was laying out the plan going forward.
Okay. She
So,
sounds
that's
just
it.
like she'll be a strong foreperson. Okay, so let
yeah,
me just.
I get
let me
that
give
feeling.
you, this is a comment we have from Michelle MDT, okay, etc. And thank you for the donation. And she's commenting about my question to you, basically. What were the highs and the lows in each presentation, each summation today? My low, she says, was Attorney Sprague, otherwise known as Jen, comments about Lindsay Clancy mom, essentially saying either Lindsay Clancy was lying to her mother or her mother lied for her and failed her. What are your thoughts about that?
Lied about what? What was the proposed lie about?
I think it was, if I recall, it was whether or not she told her mother the truth completely about the drugs she was on and all that kind of stuff. I think I think you're right. I think it's a low point. I think she told her mother she was having thoughts of homicide. Okay. So,
Yeah.
I mean,
I
how
don't
could you say
I don't
you
think you're
lied
going
to
to
the
make
mother?
a lot of points trying to create infighting with the family. I don't think it goes anywhere. There's
Right.
really no evidence of that. If there were some mistakes or inconsistencies, I'm thinking they were purely innocent. So
Right. I mean, and also people make inconsistencies out of nothing, as we've seen. I mean, something is not an inconsistency or what you perceive. Okay, so we have more jewels. Elizabeth Ellis Coach. Elizabeth Ellis Coach
wait.
has 2 jewels,
Hold on.
sparkles.
hold on. The
Okay.
she's one of the DA, not the one that's in she's one of the DA's helpers that just went by in that,
Yes, I saw that.
floral kind of dress. She was saying, you're not supposed to be here. You're supposed to be on the other side. Well, I've been here
To
for 5
you?
weeks. Been here for
To
5
you?
weeks. Yeah, to me, because I'm the only one here. Everybody else, all the media is on the other side. Well, they can be wherever the fuck they want to be. This is public space here.
Right.
Let me go
right.
talk to Kevin or the other bailiffs, or maybe Jerry, the head of security. Maybe I'll ask him. I mean,
Yeah. Really, how ridiculous. I mean, you
Yeah.
know.
Well, that's I think that's
and-
their mindset. That's what happens when you feel like the world's against you. I think you
Yeah.
lash out like that. But she's one of the helpers that has come and gone from the courtroom when the DAs need
So you
something.
may get reported tomorrow. Maybe there'll be a Massachusetts
Oh
State
my gosh.
Police to tell you you can't be on public
I was
public
telling-
property.
I was talking to Jerry, who's a super nice guy and very helpful with all the things that are happening. He is the regional director of security. So he
Okay.
did both Karen Reed cases. And
Oh,
so
wow.
that was a nice primer for him to come here. And I said, you guys are doing a pretty good job. you could do a couple of things better. In fact, we're mounting an effort to get news organizations limited to 1 seat per organization, like the NBC local, the NBC national. Grace Wong and I are on that. So that they could fix. They did have the overflow today, which was helpful. There were 32 people in there. I talked to somebody that was in there. Only a couple of media, but 30 from the public, and they were just in another courtroom with the big screen TV, usual overflow setup. And the characterization was better than nothing. They could hear everything, they could see it, but obviously they would have rather been in the courtroom. So they did a good job. But I had to tell Jerry, I said, look, I have full disclosure. I'm suing the Massachusetts State Police, and for the stuff that happened over there. And we're talking a little more about it, the buffer zone and all that. And he said, well, there was this attorney, and it's like the light bulb starts to go on. He realizes it's me. And I said, yeah, who captured Delgado being, his label being ripped off his jacket? Yeah, guilty. But he's still a good guy.
And me witness on air.
Yes.
Right.
Yes. Well, let me bring the key witness in for you. So I thought that was amusing. He is a
the
very good guy.
The key witness is the videotape, as they used to say. Go to the
That is,
videotape.
I had to sign a declaration about that when it was filed that I took it and et cetera. Anyway, so that was fun.
That's a riot. That's actually a riot. Snoopy House 610 new member. Thank you, Snoopy House, for becoming a new member. We appreciate that. Elizabeth Ellis, coach again. More 10 jewels. Hiding means kind of lurking around. Come out of the hiding. What did you say when you played hide and go seek? What were the words when you were, Oli Oli
oxen free?
Yeah, that's it.
Yeah. I don't even know what that means.
I don't even know what it means. I never know what it means when I was a kid either. Anyhow, thank you. And then Elizabeth Ellis again, 30 jewels with flour. Thank you very much. That's really, really, really nice. All right. So are you?
I have a problem. I'll tell you about a problem. Patrick, Kevin's son, Patrick, we're in the hallways. I talked to Kevin for a minute and told him I told him where he could have punched it up. No, I didn't. I told him.
No, you did not.
No, I did not. But Patrick came by and we were just saying hi, and he said something about best dressed or something. Now, here's the problem. I have to wear the shirt again tomorrow. And it's not exactly a shirt that hides from anything or anybody. It's like, bam, it's that's why this is our Justice Watch, Verdict Watch shirt. That's just what it is. So I'm torn between, people thinking I'm a bum and don't have more than one shirt and carrying on the tradition until verdict is in. I don't know.
Well, do you have a jacket that you can throw over the shirt?
I do have a jacket.
That would be fine.
That might help.
And if it's different color, it doesn't matter because
it's a dark color.
That's the thing right now is to layer different things.
Yeah, I still think it's going to be
patterns.
I'll have to seek him out and say, look, here's the deal. It's a thing.
Yeah.
It's
okay. A thing. We have 1,000 jewels here giving you, Michael, a GOAT trophy. Apparently, the GOAT trophy is kind of cool from what I see. I understand. Thank you very much to Y Robinson 3948.
Somebody said, just say you have 2 of these.
That's okay. All. Question I have: do you want to continue playing Patrick's testimony from day 1, so that tomorrow we can start anew with day 2, and then end the stream for people that have been watching it?
Yeah,
let Joy know right now. I think that's a good idea.
I really hadn't given it much thought. I'll leave that to upper management. You guys.
Okay, upper management, Joy. I think that's a good idea. We finish this day 1. That should end before our 6 o'clock show, and then we move to our 6 o'clock show, if that's okay. And then we will see you at 6. And we do have a Justice Serve TV Michael Bryant demonstration coming up.
Yes, I am the carrot top of true crime. So we'll have that, and then we have Mark Betterow. So
we have Mark Betterow. By the way, I have the skinny on why things were taken down. It's because we were, even though we were playing the closings, they were taken down because they were playing the closings, which had all those bad words that the algorithm picks up. Indicating that maybe you're a hateful channel, whereas they have a different standards, a set of standards for if you're considered a news channel. If you consider a news channel, it doesn't go into that algorithm. So I think we have to talk to YouTube. Apparently, it's from a Google algorithm, and they're all the same, right? Google and YouTube, they're one company. About we have to be rebranded as a news channel. So maybe instead of putting entertainment, we put news when we go up into our StreamYard.
Well, that's a good question. Are we in? We're in as entertainment right now.
We're in as entertainment, right? But we can switch it to news, and maybe that will help. think that maybe we should
Yeah.
do that.
Do they have infotainment on there? That's the more appropriate category. No, they don't have that.
No, I don't think so. So that may be the solution. Maybe we should talk to Bob and see how he is going to get around it. Obviously, there needs to be some kind of summit because you can't be a true crime streaming channel unless you mention all those words that they're prohibiting.
Yeah, and I've talked about it. They should have some different standard of some sort. Maybe that's as close as it gets. You just categorize yourself differently.
Yeah, and that's when we talked to Grant, he categorized himself as news, and then when he gets dinged, he fights it and he wins because he's considered a news reporting agency.
Okay. Anybody hear what happened? And did Lally get back on the stand or any of the other?
I don't know. Last time he was on the stand, and apparently the Judge Krupp, is not too user friendly to the defense, Rosemary Scapiccio. That's what that was what I was seeing on the internet, but I really haven't had time to go look, but I will.
Okay.
We're about to have a big storm again. Yes, that's thunder in case you can't hear it.
I know that's another thing that led me to stay the night and not drive back in and through that, and then in the morning come back. So I'm hanging out here. So
okay. All right.
Okay, let me take off. You take off, and we'll pick up that
see you at
Patrick
6.
Clancy testimony, and we'll see everybody at 6 o'clock. So
okay.
I was going to say enjoy, but that's really not the right word. Take this all in. It was early in the trial. It's a good refresher. So do that, and we will see you soon. Bye, guys.
Okay. Bye.
So your 2 stops then that night were going to be CVS and the 3V restaurant, correct?
Yes,
Where did you go first?
CVS.
And do you remember the route that you took to get there?
Yeah, I went out our driveway, took a right on Winter Street, and then took a left on the main road and went to CVS.
So it's a pretty direct route from your house to CVS?
Yeah.
Get the map. Just going to have you look at the screen, if you would, to a map. And coming into this red dot here, is that the approximate location of your home at 47 Summer Street?
Yeah.
And then looking at this pink dot here next to Big Y, is that where the CVS is located?
Yes.
And that's the CVS you went to that night?
Yes.
About how long did it take you to get there?
3 minutes.
And when you got to CVS, did you go inside?
Yes.
Okay. And what section did you go to in CVS?
I think it was pediatrics.
If we could pull up the CVS video. I'm going to ask you to look at the video here. Is that you entering the store?
Yeah.
Okay. And that section you head to on the right, is that the pediatric medication section?
Yeah.
Okay. And while you're in that section, looking for the medication, do you do something?
I called Lindsay
And why did you call Lindsay?
because what we were looking for wasn't there. The shelves were pretty empty. It was still during COVID.
It was, I'm sorry, what?
It was during COVID, so
Okay, so, and was that call at about approximately 5:33 p.m.?
Yeah.
Okay. And then, did she answer the call?
yes.
She answered when you called her?
Actually, I think she didn't at first. She called back.
Okay. And did you receive a call back from her about a minute later at 5:34 p.m.?
Yeah, that's correct.
Okay. And can you describe that phone call for us?
It was very brief. I just said, I think there was a generic brand, and I said, is this one okay? And she said, yeah, that's fine.
And what was her demeanor during the call?
She was pretty quiet. It sounded like she was busy. I remember hanging up thinking she's probably in the middle of giving baths or something like that.
So it sounded to you like she was in the middle of something?
Yeah.
Were you able to understand her when she spoke to you?
Yeah.
And did she seem to understand what you were saying?
Yes.
And she didn't seem to have any trouble recalling why you were at CVS or what you were looking for?
That's correct.
And did you, in fact, purchase some Pedialyx at CVS?
Yes.
Did you purchase anything else while you were there?
Bought a pack of Skittles.
Just showing you a receipt from CVS. Does this appear to be an accurate description of what was purchased?
Yeah.
We could have the CVS receipt marked as the next exhibit, please.
All right. That may be admitted.
26. And then if we could have the original CVS video marked as an exhibit and the CVS timeline, a condensed version like this, the following exhibit.
Be 27 and 28.
We have the original mark as 27 and the timeline is 28, please. It's 26, 27, and 28 is the mark.
All right. Thank you.
After you had made your purchases at CVS, where did you go next?
To 3V.
And do you remember the route you took to get there?
Yeah, I think I got on Route 3 South for just one exit. And then I got off and went straight to 3V.
And showing you the map again here on the screen. This green dot here on the bottom, is that where 3V restaurant is located?
Yeah.
Your Honor, I'd move to submit a copy, a digital copy of the map. We have it on the computer. I can make a hard copy.
All right. That may be admitted.
We can use empty case as a marker. Is it 29?
All right. Thank you.
We could pull up the 3V video, please. Now, sir, how long approximately did it take you to get from CVS to 3V?
Probably around 10 minutes.
And when you got to the 3V restaurant, did you go inside?
Yeah.
I'm just going to ask you to watch the video on the screen. At 5:54, 15 p.m., is that you coming in behind that other couple there?
Yeah.
And what are you doing at that point when you're looking at the bags?
I think I was looking for the bag with my name on it.
Do you recall what you're doing on your phone at that time?
I don't. It could be work related, could be anything.
And the order that was listed under your name and phone number, correct?
I think Lindsay ordered it.
Right, but do you recall whose name it was under when you picked it up?
I don't recall specifically, but it could have been mine.
show you a receipt here from 3V Restaurant for Mediterranean Powerball and Scallop and Pork Belly Risotto. You could just look at the name and the number on the receipt.
Yeah, that's my name and my number.
So that's your phone number?
Yep.
Okay. So although the defendant called in the order, your name and phone number were given and were given accurately, is that correct?
Correct.
If we could have the 3V video marked as the next exhibit.
Sure. That may be admitted.
Got it.
Yeah. Can I see counsel just very briefly?
Sir, after picking up the order at 3V, where did you go next?
Home.
And do you recall the route you took home?
Probably the same route, one exit on the highway, and then went home.
Okay. Do you recall approximately how long it took you to get home?
I would guess 10 to 12 minutes.
When you arrived home, where did you park?
In the driveway.
What type of car did you drive then?
A Chevy Silverado.
And was that a white pickup truck?
Yeah.
What kind of car did Lindsay drive then?
It was a Kia SUV.
And once you parked there, were both vehicles now in the driveway?
Yeah.
I'm going to show you a series of photographs of the exterior of your home. You could just look through them and tell me if they accurately reflect how your home looked on January 24th, 2023.
Yeah, these are accurate.
You could have these photographs of the exterior of the home, front and back, marked sequentially as exhibits.
They may be admitted. Thank you.
It's 32 through 37, no, 38, so far. Sir, showing you what's been marked as exhibit 32. Is this the front of your house with the main door?
Yes.
And then showing you what's been marked as exhibit 33. Where is this in relation to that main front door?
It's to the right.
And here where the light is that a secondary entrance at the front of the house?
Yes.
And for the record, that's to the left of the garage?
Yeah.
Showing you exhibit 34. Can you tell us what portion of the house this is?
It's to the left of the front door.
So if I'm facing the front door, it's to the left, there's a fence there, is that correct? And exhibit 35, is that more of that same fence on the left?
Yes.
And then showing you exhibit 36, is this looking at your backyard from that left side area where the fence is?
Yeah.
And then exhibit 37, can you tell us what we're seeing here?
This is the back of the house and the window where Lindsay jumped out.
And exhibit 38, is that a more direct view of that back of the house?
Yeah.
And so the window you referenced about Lindsay, is it this upper right top window?
Yeah.
And what is behind that window?
Our bedroom.
And the window to the left there in the middle, what room is that window in?
That's the upstairs bathroom.
And then the top window on the far left, what room is that for?
That was Dawson's bedroom.
Dawson's, okay. And then directly below the top right window, so the bottom far right window, what room is that window for?
The living room.
And then again, the middle window on the bottom level.
Downstairs bathroom.
And then that window on the far left there, is that the kitchen?
Yeah.
And on the far left of the photo where the sliding glass doors are, where does that lead into?
There's like a room off of the kitchen where there's a kitchen table.
When you got home and you parked your truck, how did you get into the home?
I went in through that side door.
The door that was to the left of the garage?
Yeah.
And what did you do once you got inside the home?
I started taking my boots off.
And did you have some bags with you from CVS and 3V?
Yeah.
Where did you place those?
On the kitchen island.
Show you a couple photos of that area when you came in. Just tell us if it accurately represents how they looked, that area looked on January 24th, please.
Yeah, that's accurate.
Could have these two photos marked with the next exhibit, please.
It may be minute.
Exhibits 39 and 40. So we're showing you what's been marked as exhibit 39. Can you tell us where the sliding glass doors are in this photograph?
They're to the left of the kitchen table.
So we have here the kitchen table, and kind of in the center of the photograph, is that correct?
Yeah.
And so these are the sliding glass doors?
Yeah.
And where's the door that you came through?
To the right after the kitchen table.
Right here, next to the curtain?
Yeah.
And the door, when you're looking at the photo straight ahead, this door to the left of the mirror or the photo there, where does that lead?
The garage.
And then showing you exhibit 40. Is that where you place the bags on the island in the kitchen?
Yeah.
When you came into the house and you were taking off your boots and putting things down, was there anything you noticed?
Yeah, the house is really quiet.
Is that unusual?
Yeah.
And when you realized it was really quiet, what did you do?
I called out.
And who did you call out to?
Everyone.
Did anyone answer?
No.
After you called out and no one answered, what did you do next?
I think I don't know the order, but I called down in the basement and no one answered. And then I called Lindsay to see if she was home because I looked out and I couldn't see her car, but it's because it was dark and her car's black.
Okay, so when you say you called down to the basement, when you approached the basement door, do you remember if it was open or shut?
It was shut.
So did you open it and yell down?
Yeah.
And there was no response?
Correct.
And showing you a photo here, is that a fair and accurate depiction of the stairway down to the basement level?
Yeah.
We could have this marked as the next exhibit, please.
That may be admitted.
Exhibit 41. Do you recall when you opened the door to yell down whether the light was on or off?
Yeah, it was on, but Lindsay always left the light on.
And you said you called Lindsay, was that a phone call?
Yeah.
And was that at approximately 6:09 p.m.?
Yeah.
And did she answer?
No.
After calling down the stairs to the basement, did you leave the door open or did you close it?
I don't remember.
Okay.
I would think I closed it because I always try to keep it closed. I'm not sure.
Okay. And so after you called Lindsay and didn't get a response, what did you do next?
I started checking upstairs.
And where did you check upstairs?
First, the bathroom. I thought maybe they were taking baths, but there's no one there.
And then where did you go?
The kids' bedrooms.
Was there anyone in the kids' bedrooms?
No.
And then did you go to your bedroom?
Yeah.
And were you able to get into your bedroom right away?
No, the door was locked, and that's when I knew something was wrong.
And when you realized the door was locked, did you have a way to unlock it?
Yeah, the previous owners, when they installed the doorknobs, had these like these little keys that they taped to the back of each door. So I got the one from Cora's room, and I started unlocking the knob.
Okay. And when you unlocked the door to your bedroom, did you go in?
Yeah.
And what did you see when you opened the door and went in?
I just saw blood everywhere, and the window is open.
And showing you here a photo, is this the bed in your bedroom?
Yeah.
Now, the way the bed is in this photo, kind of pulled away from the wall and slightly askew or at an angle, is that the way it was typically?
No.
And when you left the bedroom that day for the last time prior to coming home later that night, was the bed in that position?
I don't think so.
It has this photo there.
It may be admitted.
Exhibit 42. And you said you saw the window, is that correct?
Yeah.
Was it open?
Yeah, there was wind blowing in.
Showing you a photo here. Is that a fair and accurate depiction of how the window looked?
Yeah.
Mark, what's the next exhibit, please?
That may be admitted.
Exhibit 43. Did you walk into the room and over to the window?
No.
How far into the room did you get?
Probably 1 or 2 steps, and then I immediately turned around and went outside.
And the blood that you saw, where was that located in the room?
It was everywhere. It was, it looked like it was sprayed almost with like a hose, and there was a huge puddle in the middle of the room, and it was sprayed all over pretty much every surface. I remember it was on the doorknob.
Okay. Showing you 3 photos. Do you recognize what's depicted there? And is that a fair and accurate depiction of how the room looked on January 24th, 2023?
Yeah.
We could have these photos, 3 photos marked as the next 3 exhibits.
It may be admitted.
So they're showing you what's been marked exhibit 44. Is this the entrance to the room, looking into the room?
Yeah.
And then exhibit 45, is this mirror to the right of that bureau we were just looking at?
Yep.
And 46, is this the entrance to the room, looking into the room?
Yeah.
And 47, is this the mirror to the right of that bureau we were just looking at? And 48, is this the entrance to the room, looking into the room? And 49, is this the mirror to the right of that bureau we were just looking at? This area right here, is this the blood you were referring to?
Yeah, that's some of the blood.
And then in exhibit 46, is that getting closer to the window?
Yeah.
And is that more of the blood that you were talking about?
Yeah.
Going back to exhibit 42. There's no blood on the walls or on the bedding, correct?
On those walls and the bedding, correct.
Sir, were you aware that the defendant's phone was found on the bed in the bedroom that night?
Yeah.
They're showing you this phone with this light brown case. Do you recognize this?
Yes,
Whose phone is it?
that was Lindsay's phone.
And is this the phone that she was consistently using between September of 2022 and, well, actually August of 2022 throughout the fall and into January of 2023?
Yeah.
You have this marked as an exhibit.
That may be admitted.
47. Sir, after making those observations in the bedroom, what did you do next?
I ran downstairs and went outside.
And do you recall whether you went out the front door or the back door?
I went out the back door.
So that would be the sliders, is that right?
Yeah.
And where did you go from there?
I just looked around in the backyard below that window and I saw Lindsay.
And where did you see her?
She was face up in the backyard
And where in the backyard was she?
at the bottom of the window.
And so, looking at exhibit 38, you said this was the window, correct, the top right?
Correct.
Where was she in relation to that window?
Directly below it.
So down here by the window well?
Yeah.
For the record, I was pointing straight below the bottom right window by the window well. I'll show you a photo of that window you were referring to. Is this the exterior view of that window to your bedroom that night?
Yeah.
We could have this marked as an exhibit, please.
That may be admitted.
To the 48. Showing you exhibit 48. So the window's open, correct?
Yes.
And the screen for the window is up, correct?
Yeah.
At any point in time that night or afterwards, did you notice that the screen was cut or broken in any way?
I didn't notice that, no.
And when you saw Lindsay on the ground there under the window, which direction was her body facing?
Her head was closer to the house. Her feet were away from the house.
Okay. And did you go to her?
Yeah.
And did you observe any injuries?
Yes.
And what did you see?
She had deep cuts on her wrists, and she had a red line across her neck. I wasn't sure what it was at first, but she cut her neck.
And do you recall that these wounds weren't actively bleeding at the time?
I later learned that I said that on the 911 call.
And when you observed these wounds, is it correct that the 911 operator asked you or instructed you to apply pressure if needed?
I don't recall the whole call, but I believe that's probably true.
Okay. And you didn't at the time feel the need to apply pressure to any of those wounds, correct?
Correct.
Did you say anything to Lindsay when you found her in that state?
Yeah, I said, what happened?
And what was her response?
She said, I tried to kill myself.
Did you ask her anything else?
I said, where are the kids?
And what was her response?
She said, they're in the basement.
And at that time, she didn't tell you that they needed help or they were in danger or they were injured, correct?
Correct.
And so you mentioned talking to someone on 911. At what point did you call 911?
I don't know the exact time, but it took a few minutes because my phone was switching between Wi-Fi and 911. So I almost just started calling out for the neighbors, but eventually it went through.
Okay. So you had some difficulty connecting, but eventually you connected to the 911 operator?
Yeah.
Okay. And did you stay on the phone with them while they were sending people to respond?
Yeah.
Okay. While you're on the phone with 911, are they asking you questions and you're responding with information about her condition?
Yeah.
And if you could just look at the screen here, is this the model of the first floor of your home?
Yes.
And so we have here the sliding glass doors. Where would the basement door be in this model?
Directly below the stairs.
So now that it's flipped around, is this the door to the basement right here?
Yeah.
And for the record, that's the door across from the downstairs bathroom?
Yeah.
And then, how long approximately, and I know you weren't looking at your watch or anything like that, but can you estimate for us how long it took for first responders to arrive?
4 or 5 minutes.
Okay. And during that time, are you continuing to try to talk to Lindsay?
Yeah.
Is she responding?
She's in and out of consciousness.
Okay. Was she breathing on her own?
I believe so.
Okay. And you're communicating information to the 911 operators, and are they giving you, advice on how to deal with the situation as it progresses?
Yeah.
Okay. Once emergency personnel arrive, what do?
I immediately got up and ran to the basement.
Okay. And do you still have the phone on you? You're still on the 911 call?
Yeah, I didn't realize it at the time, but I did.
Okay. And have you look at this model here on the screen? Is this a fair and accurate depiction of the setup of your basement?
Yeah.
Okay. If you can just describe the rooms for us, what the purpose of each room was.
So the room in the back left was my office. the room with the black rubber mat is the gym. And then there's the living room to the right of that. And then the back right is just an area of the living room. And then there's a bathroom next to that.
So when you come down those stairs that night, which direction did you go?
Immediately went left.
And when you went left, what did you see?
I saw Cora.
And how did she look?
She had a band around her neck.
And was that an exercise band?
Yeah.
And do you recall whether she was, what position she was in, whether face up or face down?
She's face down.
And when you saw her in that condition, what did you do?
I immediately ran over and tried to take the band off.
Were you able to get the band off?
Yeah.
And do you recall how you got the band off?
I think I untied it.
And when you say untied it, was it in a knot that you had to, put everything down and unknot it, or how was it tied?
I'm not sure I fully remember.
Do you recall describing it previously as when you initially tie your shoes, but then don't do the bow?
Yeah, that sounds right.
And was she responsive?
No.
And what did you see or do next?
I saw Callan.
And where was he?
He was next to her.
And how did he appear?
He had a band around his neck.
Sorry?
He had a band around his neck.
And did you remove that as well?
Yeah.
And do you recall what position he was in?
Same as Cora.
And looking at the model here, if you could just tell us, where was Cora?
The left of the couch.
So would that be this area here that I'm pointing to, in between the bureau and the couch?
Yeah.
And where was Callan?
To her left.
So would that be more over here towards the chair and the bureau?
Yeah.
After you removed the band from Callan's neck, what did you do next?
I tried to find Dawson.
And where did you go?
I looked in the bathroom and on the other side of the couch. And then I went to the other side of the basement and he was in my office.
And when you saw Dawson, what condition was he in?
I knew he was gone.
And did he also have a band around his neck?
Yeah.
And did you remove that band?
Yeah.
And looking at the office here, where was he located within the office?
Just to the left of the door when you went in.
Just in this area here, right inside the door?
Yeah.
So we may approach briefly.
Yeah, please.
Now, after finding Dawson and taking off the band, what happened next?
I think I was back and forth. I think I went to try to help Cora.
Did you try to give her CPR?
Yeah.
At some point in time, do the first responders make their way down to the basement?
Yeah.
And do they take over care of the children?
Yeah.
Where do you go?
They sent me upstairs.
Okay. And at this point, Your Honor, I'd move to submit the 911 call as the next exhibit.
That may be allowed pursuant to the earlier order.
Cora, Dawson, and Callan removed from the home and taken to a hospital.
Yeah.
Was that Beth Israel Deaconess in Plymouth?
Yeah.
Did you also go to that location?
Yeah.
And at the hospital, were you able to see your children?
Yeah.
And was Callan then transported to Children's Hospital?
Yeah.
Did anyone ever tell you not to leave your kids alone with Lindsay?
No.
In January of 2023, did Lindsay ever tell you that she wanted to harm your children?
No.
Did she ever tell you she was going to kill your children?
No.
Did you receive, a few days after this happened, did you receive a phone call from the defendant while she was at Brigham and Women's Hospital?
I think it was like a week or so after, yeah.
And what did the defendant say at that time about what had happened with the children?
She didn't talk about our kids. She talked about what she went through.
And what did she say about what she went through?
She said she heard a man's voice telling her that if she didn't do it now, she would lose her chance or something like that.
And did she also tell you that she had had a moment of psychosis?
I don't recall.
Did she mention the children at all during that call?
I don't think so. I mean, not directly.
Had she ever mentioned psychosis to you before?
No, I didn't know what psychosis was until after this happened.
Did she ever tell you she was hearing a man's voice before?
No.
If I may have a moment, Your Honor.
Sure.
I have no further questions for this witness.
All right.
I just have exhibits
All
after.
right. Counsel, can I see you just briefly sidebar?
Down the shirt. And then the pink robe. We could have these marked as one exhibit.
They may be admitted. Thank you.
And then Dawson's clothing. We have dinosaur underwear for the record. And a gray t-shirt or shirt, long sleeve shirt. Have this as the next exhibit, please.
That may be admitted.
Exhibit 2. And then Helen's pajamas. this the next exhibit, please?
That may be admitted.
Yellow exercise band found with Dawson. Now this is the next exhibit, please.
That may be admitted.
Black exercise band found with Cora. Now this is the next exhibit, please.
That may,
And then the blue exercise band found with Callan. You could have this as the next exhibit, please.
that may be admitted.
Your Honor, we would ask that the 911 call be played.
All right. All right. Members of the jury, I just kind of wanted to give you, all right. Sometimes in a trial, evidence that is introduced that produces in jurors an emotional response. For example, it's understandable to feel sympathy and empathy when you hear or see certain evidence. And so, but as jurors who have taken an oath to follow the law, I'm instructing you that the law says you must separate any emotional reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the unpleasant nature of some of the evidence, including testimony, including exhibits. And so you must find the facts in this case based only on the evidence. And so you can't find facts or base your decision on sympathy, anger, passion, or prejudice or pity for or against either side. Rather, your verdict must be based solely on the evidence that is introduced in this case and my instructions and any other limiting instructions. And I'll go into that, but I just kind of wanted to remind you of that as we go through this. All right, at this point, we're going to play the exhibit, which is, I believe, the 911 call. Is that correct?
Yes, Your
All
Honor.
right. I want to remind everyone that there is a order entered by the court regarding this matter. It's not to be recorded. It's not to be broadcast. And it's not to be reproduced in any way, subject to any sanctions that would go along with the violation of that court order. So I just kind of remind everybody that order applies to the media and applies to the public. So I just kind of wanted to remind everybody in regards to that. So with that, Commonwealth?
Jurors, close your notebooks, place them on the chairs. Follow me, please.
My drugs go.
Jurors declare to the courtroom, the court's in session, please be seated.
We'll be in recess at this time.
Thank you.
Court, all rise.
Court is in recess, please exit the courtroom, clear out the courtroom, please, thank you.